Northons Media PR and Marketing Limited presents the Global IP Matrix Magazine Issue 23. GIP Matrix 23, front cover text. What's hot in China's trademark practice? The legal uncertainty behind viral fan edits. Patent thickets and overlap, how attorneys and analysts collaborate in the CRISPR Cas9 maze. Understanding compulsory licensing, a Sri Lankan perspective. Copyright enforcement in the digital age, the case of Ghana and Nigeria. CNIPA's latest regulatory updates on 3-year non-use cancellation applications, the equilibrium between procedural rigor and rationality. Main front cover heading. The Power of Patent Data in Research and Business Strategy. Written by Kenichi Nakajima, Director of IP Services, Japan, Clarivate. Front cover strip advertisement. AIPPI World. Patent Intelligence Platform and Research Services. www.paitworld.com, mail at paitworld.com, telephone, +44 01633 816 601.
Page 2. Inside front cover advertisement. IP Tech and Innovation Services Annual. Spotlighting the game changers delivering innovation and support across the IP industry. Our exclusive sponsor, LexisNexis. Stand out in a market of uncertainty. Only 21% of IP professionals feel well informed about available platforms. The rest are searching for clarity and will find it here. We're calling on IP tech providers to feature in the IP Tech and Innovation Services Annual 2026, share success stories, present impactful case studies, demonstrate proven results, and connect with the global IP community seeking trusted solutions. Supported by Clarivate and AIPPI World Global IP Research Services. Official media partners. IP Service World, Munich, Germany. 24th and November 25th, 2025. Email, technovation@northonsprmarketing.com. +44 02038130457. www.iptechnovation.com.
Page 3. Editor's Note. Dear readers, welcome to the AIPPI World Congress 2025, Japan, Conference Special Edition of the Global IP Matrix Magazine. As one of the year's most significant gatherings for intellectual property professionals, the AIPPI Conference provides a vital platform to share insights, challenge assumptions, and forge connections across borders. This issue's headline feature, by Kenichi Nakajima of Clarivate, offers a masterclass in unlocking the power of patent data in research and business strategy. With Japan as a backdrop, the article explores how enriched patent datasets and advanced analytics are transforming decision-making for corporations, universities, and policymakers, a timely read for anyone navigating fast-moving innovation ecosystems. From Latin America, Adriana Barrera of Barlaw, Barrera and Asociados delivers an incisive look at landlord liability in trademark infringement cases in Peru. Her piece outlines how holding property owners accountable can disrupt counterfeit supply chains, strengthen enforcement, and protect brand integrity. We also spotlight a critical issue affecting the creative economy in West Africa. Sarah Norka Anku of SN Anku IP firm examines the realities of copyright enforcement in Ghana and Nigeria, highlighting the legislative gaps, cultural perceptions, and enforcement challenges that continue to fuel digital piracy, and offering practical recommendations to strengthen protection in the digital era. Beyond these features, this edition is filled with diverse contributions covering patents, trademarks, and copyright, as well as jurisdiction-specific updates and commentary on emerging IP challenges. Whether you are here in Yokohama or following from afar, we invite you to explore the full range of perspectives and practical insights within these pages. We are grateful to our authors for their expertise and to you, our readers, for being part of this ever-growing global IP community. As we look ahead, may the conversations at this year's conference, and the knowledge shared in this magazine, inspire innovation, collaboration, and progress in the field of intellectual property. The Management Team. Northons Media PR and Marketing Limited. Published by Northons Media PR and Marketing Limited. Carlos Northon. CEO and founder, Northlands Media PR and Marketing Limited, publisher of the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Carlos at northlandsprmarketing.com. Dhruva Dakani, Director of Creative Design and Global Marketing for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Dhruva at northlandsprmarketing.com. Hitanshi Gohil, Junior Graphic Designer and Researcher for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Hitanshi at northlandsprmarketing.com. Kushnuma Sama, Sales Account Executive for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Kushnuma at northlandsprmarketing.com. Zafira Hudani, Reporter at for Northlands Media PR and Marketing Limited for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Zafira at northlandsprmarketing.com. Craig Barber, Head of Design for the Global IP Matrix, the Women's IP World and the Caribbean IP Annual. Info at northlandsprmarketing.com. Disclaimer: all images in the articles are provided by the authors, unsplash.com, pixabay.com, pexels.com, canva.com, freepik.com and vecteezy.com. Page 4. Editorial Board of Directors. Malden Vukma, Vukma Attorneys, Croatia. Keisha Fleming Lake, Managing Partner at Cerveri Monsuarez, Anguilla. Laura Collada, Managing Partner, Dumont, Mexico. Max Montero, Partner, Johansson and Langlois, Chile. Ray Zhao, Senior Partner at Unitlan Attorneys at Law, China. Sarah Norka Anku, Managing Partner, S.N., Anku IP Law Firm, Ghana. Page 5. Contents page. Page 9. Copyright Enforcement in the Digital Age, The Case of Ghana and Nigeria. Written by Sarah Norka Anku, Global Managing Partner and co-author by Onyenichukwu Mary Magdalene Okeya-Dotsi, Head of Nigeria Office at SN Anku IP Firm, Ghana. Page 13. The Legal Uncertainty Behind Viral Fan Edits. Written by Michelle S. Katz, Founding Partner at Advitum IP LLC, USA. Page 15. What's Hot in China Trademark Practice. Written by Jimmy Huang, Head of Trademarks and Yang Zhong, Partner at East IP, China. Page 20. Landlord Liability in Trademark Infringement Cases in Peru. Written by Adriana Barrera, Founder and Managing Partner at Bolo Barrera and Asociados, Peru. Page 23. CNIPA's latest regulatory updates on 3-year non-use cancellation applications, the equilibrium between procedural rigor and rationality. Written by Robert Chan, Founding Partner and Head of the Trademark Department, and Yura Wang, Deputy Manager and Senior Trademark Attorney at Sun & Chan Intellectual Property Company. Limited. China. Segment. Behind the Brief. Page 26. Half a Century of Experience in IP. Profiling Dr. Totyana Vaknina, Senior Partner and Founder of Vaknina & Partners, Eurasian Patent Attorney, Patent and Trademark Attorney of the Russian Federation. Page 29. Brief account on compulsory licensing of patents with relevant provisions of Sri Lanka law. Written by Anomi Wanigasekara, Senior Partner at Julius & Creasy, Sri Lanka. Page 31. The Power of Patent Data in Research and Business Strategy. Written by Kenichi Nakajima, Director of IP Services, Japan, Clarivate. Page 35. Legal Aspects of Compulsory Licensing in the Pharmaceutical Sector in Russia. Written by Yevgeny Alexandrov, Senior Partner at Gorodisky & Partners, Russia. Page 39. From Milan to the Metaverse, Simona Lavagnini on IP law, innovation, and Italy's global role. LGV Avvocati's founding partner shares expert insights with Northlands media reporter Zafira Hudani. Page 42. Patent thickets and overlap, how attorneys and analysts collaborate in the CRISPR Cas9 maze. Written by Joshua Beverly, Senior Patent Analyst at Patworld Limited and Dr. Michael A. Roberts, Partner at Red Dye and Grows LLP, United Kingdom. Page 47. The Digital Disconnect, 78.57% of IP professionals seek clarity in tech platforms. Written by Carlos Norton, founder and CEO at Northons Media PR and Marketing Limited, United Kingdom. Page 49. From Fragmentation to Integration, UNH Franklin Pierce's Hybrid JD and the Future of Global IP Education. Written by Seth C. Orenberg, Professor of Law at UNH Franklin Pierce School of Law, USA. Page 51. Protecting a Trade Secret from the West to the East. Written by Zafira Hudani, reporter at Northons Media PR and Marketing Limited. United Kingdom. Segment, Conference Corner. Page 55. AIPPI in Motion, Vision, Action, and Regional Impact. Written by Luis Enriquez, President of AIPPI. Page 57. Daniela Bopp and Elena Backhaus share their perspectives on IP Service World 2025, where global IP leaders connect and shape the future. Zafira Hudani, reporter at Northons Media PR and Marketing Limited, speaks with the key organizers of Europe's largest IP event. Page 61. Navigating the Future of IP, Why Europe and the UK Are at the Center of Global Innovation. Written by Cosmonauts, United Kingdom.
Page 6. Advertisements. Advert 1. The Global IP Matrix Magazine. Elevate your 2026 branding strategy with the Global IP Matrix. Strengthen your presence in the international IP landscape by incorporating the Global IP Matrix magazine into your 2026 marketing plan. Reach a diverse, global audience of IP professionals and industry leaders. Winners of the SME Greater London Enterprise Awards. Awarded IP Marketing and Consultancy Agency of the Year 2025 by Corporate Livewire, Innovation and Excellence Award. The Global IP Matrix magazine is ranked number 1 on Google. info@gipmatrix.com. www.gipmatrix.com. Advert 2. United Trademark and Patent Service. Intellectual Property Attorneys. Your reliable partners for intellectual property matters in Pakistan, South Asia, Arabian Gulf, Middle East, and Africa. Trademark, patent, design, copyright, domain name registration, litigation and enforcement law. Pakistan Office. 85, The Mall Road, Lahore 54000, Pakistan. Adjacent Radho Kronos / Hang 10 Mall Plaza Building. Telephone. +92 42 3628 5588 to 90. +92 42 3628 5581 to 84. Fax. +92 42 3628 5585, 3628 5586, 3628 5587. Email, unitedtrademark@unitedtm.com. Websites www.utmps.com and www.unitedip.com.
Page 7. Contributors. The Global IP Matrix Magazine Issue 23. Jimmy Huang, Head of Trademarks at East IP, China. Yang Zhong, Partner at East IP, China. Luis Enriquez, President of AIPPI. Simona Lavagnini, Founding Partner at LGV Avvocati, Italy. Michelle S. Katz, Founding Partner at Advitum IP LLC, USA. Joshua Beverly, Senior Patent Analyst at Patworld Limited, UK. Dr. Michael A. Roberts, Partner at Red Dye and Grows LLP, UK. Kenichi Nakajima, Director of IP Services, Japan, Clarivate. Anomi Wanigasekara, Senior Partner at Julius & Creasy, Sri Lanka. Adriana Barrera, Founder and Managing Partner at Balo Barrera and Asociados, Peru. Zafira Hudani, Reporter at Northern S Media PR and Marketing Limited, UK. Sarah Norka Anku, Global Managing Partner at SN Anku IP Firm, Ghana. Yevgeny Alexandrov, Senior Partner at Gorodisky and Partners, Russia. Seth C. Orenberg, Professor of Law at UNH Franklin Pierce School of Law, USA. Elena Backhaus, Team Lead Sales at the IP Service World Congress, Germany. Carlos Norton, Founder and CEO at Northern S Media PR and Marketing Limited, UK. Yura Wang, Deputy Manager and Senior Trademark Attorney at Sun & Chan Intellectual Property Company Limited, China. Dr. Tatyana Vaknina, Senior Partner and Founder at Vaknina & Partners, Russia. Robert Chan, Founding Partner and Head of the Trademark Department at Sun & Chan Intellectual Property Company Limited, China. Daniela Bopp, Senior Conference Manager at the IP Service World Conference, Germany. Onyenichukwu Mary Magdalene Okeya-Dotsi, Head of Nigeria Office at SN Anku IP Firm, Ghana.
Page 8. Advertisement. Singh & Singh. Singh & Singh Law Firm LLP is an Indian law firm with years of experience in providing services inter alia in the field of intellectual property law, media and telecommunications laws, arbitration, competition law, law of taxation, drugs regulatory laws. With a highly qualified and experienced team of legal professionals, the firm is able to identify the core of a client's issues to provide suitable solutions. Singh & Singh Law Firm LLP. C139, Defence Colony New Delhi, 110-024, India, T +9111 4982 6000 to 6090. Email at singhandsingh.com.
Page 9. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Copyright enforcement in the digital age, the case of Ghana and Nigeria. Standfirst, Sarah Norka Anku, Global Managing Partner, and Onyenichukwu Mary Magdalene Okeya-Dotsi, Head of the Nigeria Office at SN Anku IP Firm, Ghana, co-author this article, discussing the challenges facing the creative industries in these two West African countries due to rampant copyright infringement in the digital landscape. Copyright enforcement remains a matter of concern for the creative industry in Ghana and Nigeria. The flagrant and blatant infringement of copyrighted works is even more alarming in the present digital age, particularly in matters relating to musical and audiovisual works. Enforcement of copyright in such eligible works has become more complex, demanding strategic enforcement measures on a case-by-case basis. In the current digital age, content creation and dissemination have become increasingly easier with the proliferation of the Internet, mobile technologies, and social media, which have transformed how content is created, shared, and consumed. A single click of a button can replicate and share a work of art, music, literature, or video with a global audience. While this shift has opened doors for creativity and innovation as well as democratized access to information and creative works, it has also given rise to widespread copyright infringement, particularly in developing countries such as Ghana and Nigeria. These nations face unique challenges in enforcing copyright in the digital sphere because the ease with which digital content is copied and distributed without the consent of the rights holders has challenged traditional frameworks of copyright law, demanding new approaches to copyright protection, enforcement, education, and regulation. In recent times, Nigerian celebrities have accused some Ghanaian television stations of copyright infringement for broadcasting their movies without proper licensing. For example, in April 2025, Bimbo Ademoye and Omoni Oboli publicly accused some Ghanaian television stations of such copyright infringement. Some Ghanaian influencers supported the accused television stations, arguing that showing Nigerian films with or without consent from the copyright owners is free promotion for the Nigerian film industry and that the celebrities in question should rather be grateful for the purported actions of the television stations. The resulting furore caused the minister responsible for communications to issue a statement, reaffirming Ghana's commitment to respecting the IP rights of persons and to carry out its own investigations into the matter. In light of this, we aim to provide more insight into the current events in IP and the digital landscape of both countries, focusing on the copyright infringement allegations among participants in the creative arts industry. Legal framework. In Ghana, copyright is governed by the Copyright Act, 2005, Act 690, as amended by the Copyright Amendment Act, 2009, Act 788, and its regulations, Copyright Regulations, 2010, L. I 1962, as amended. Internationally, Ghana is party to the Berne Convention for the Protection of Literary and Artistic Works, Berne Convention, Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS Agreement, the WIPO Internet Treaties, the WIPO Copyright Treaty, WCT, and the WIPO Performances and Phonograms Treaty, WPPT, among others. The Office of the Administrator of Copyright, Copyright Office, oversees the administration of copyright and related rights in Ghana, with the Copyright Administrator having full powers, including the power to mediate copyright-related disputes. Disputing parties litigate their differences in court, with the High Court, Commercial Division, having original jurisdiction over such matters. There are specialized rules in Ghana's High Court, Civil Procedure, rules governing IP-related disputes with appropriate remedies, which appear to have domesticated all the provisions of the TRIPS Agreement on IP remedies. Also, under the copyright laws of Ghana, copyright infringement is an offense investigated by the Criminal Investigation Department of the Police Service, with the accused person prosecuted in court. Where the accused is not a legal person, such as a television station, those in control of the television station will be prosecuted. In Nigeria, copyright is governed by the Copyright Act, 2022, Act No. 8 of 2022. Internationally, Nigeria is party to the Berne Convention, TRIPS Agreement, the WIPO Internet Treaties, and the Universal Copyright Convention 1952, among others. The Nigerian Copyright Commission, NCC, administers the copyright laws of the country. Copyright owners may enforce their rights as civil matters in court or as criminal matters through the NCC, which charges the infringer in court. Challenges in the digital era. Technological advancement versus legislative lag. The copyright laws of both Ghana and Nigeria seek to protect the rights of authors in their literary, musical, and artistic works, as well as the rights of performers, producers of phonograms, and broadcasting organizations. However, the speed of technological advancement has outpaced the requisite legislative development to address resultant harm to the rights of persons. Nigeria has made provisions for infringement of copyright in the digital space in Act No. 8 of 2022. It has also been argued that the reliefs provided in the Nigerian Copyright Act, 2022, are grossly inadequate as they only offer for the takedown of infringing content and do not provide for any form of compensation for infringement after said content is taken down. Ghana, however, does not have any provision in the Copyright Act, 2005 that seeks to regulate the digital space. Rather, some limited provisions have been made in the Electronic Transactions Act, 2008, Act 772, which seeks to create certain liabilities on service providers and intermediaries to effect takedown actions. In effect, both jurisdictions have taken some steps to secure copyright in the digital space. Nonetheless, the level of security is inadequate as the laws do not provide for measures to compensate the copyright holder for the infringement or to deter infringers from further infringing activities, as the consequences remain a takedown simpliciter. One could also argue that the remedies available for copyright infringement also apply to infringement in the digital space. Public awareness and education. There has been some considerable education and sensitization on the matter, but many Nigerian and Ghanaian citizens are unaware that online downloading and sharing of copyrighted materials without permission is illegal, hence the support for the infringing activities by some Ghanaians in the Bimbo Ademoye case. Again, the seeming attitude of a lack of recognition of copyright may also be attributable to certain cultural beliefs and practices which favor free access to intangible property such as IPRs over legal ownership. In such circumstances, the only available means to secure such rights is through secrecy, which is impracticable in the case of copyright-eligible works such as films and music. For now, it appears both the Nigerian and Ghanaian public generally considers works of creatives simply as content, without more. Weak industry protection. Artists in both Ghana and Nigeria often lose revenue due to piracy, illegal downloads, unauthorized streaming and plagiarism, thus discouraging creativity and investment in the creative sector. The Nollywood film industry, one of the largest in the world, reportedly loses millions of dollars annually to digital piracy. The NCC seems to have awoken and is on a campaign to eradicate piracy, as there have been significant records of enforcement measures taken by the NCC against copyright infringement. Examples include Charge NO, FHC a UI of 53C 2015, where one Yugaku was charged by the NCC with 2 counts of copyright infringement for selling and possessing infringing copies of various literary works. The trial court found the appellant guilty and sentenced him to 1 year's imprisonment or a fine. In the ongoing case of NCC v. MTN Nigeria FHC ABJ CR 111/2024, NCC has charged MTN for using copyrighted musical works, including tracks such as 911 and Stop Racism, as caller ring-back tunes without authorization for the period 2010 to 2017. Notwithstanding NCC's efforts, copyright infringement continues to ravage the creative industry, and there is a need for more to be done. In Ghana, most infringement cases are handled as civil cases in court. There are some ongoing criminal investigations against local and foreign institutions on copyright enforcement matters. It is the author's opinion that the subject of copyright appears incomprehensible to some law enforcement agents as they fail to perceive such rights as assets requiring protection. Again, in recent times, accusations have been made against some individuals responsible for the protection of copyright for preying on their victims by licensing and, in some cases, assigning the rights of illiterate and semi-literate rights holders to third parties without the consent of the rights holders. Most of such appropriated copyright works are currently being exploited in the digital space. This trend has occasioned huge losses in royalties as well as the value of the copyright work in certain citations. A Nigerian case study with real-world impact. Femi Adebayo v. Afarivo TV, online YouTube channel, FHC IBCS 17/2020, dated the 23rd of April 2024. In March 2021, Femi Adebayo, a Nollywood producer, initiated legal proceedings at the Federal High Court for alleged copyright infringement of his film Survival of Jalili against Murphy Ben International via its YouTube channel Afarivo TV. The defendant reposted trailers of the plaintiff's 2019 film Survival of Jalili to promote and attract views and add revenue for another film titled Kodi Ologbon I, thereby misleading the public and viewers. The defendant's actions misled viewers into believing they were accessing Adebayo's original work, diverting revenue meant for him while boosting their own YouTube channel's views and earnings online. The court gave judgment in favor of the plaintiff and awarded NGN 20 million Nigerian nairas, approximate £9,605 sterling, in damages and NGN 5 million Nigerian nairas legal costs in favor of the plaintiff. This case underscores the urgent need for stronger measures to combat copyright infringement to protect the IP rights of creatives in the digital space. It also serves as a reminder of the importance of vigilance and proactive measures by the creatives in safeguarding creative works. Recommendations. 1. Strengthening of legal frameworks. Update copyright laws to reflect digital realities, including provisions for appropriate enforcement of online content and streaming services. 2. Enhance enforcement mechanisms. Education of cybercrime units and judiciary personnel on digital IP rights issues and the need for the same to be treated specially because of the peculiar nature of the digital space. 3. Use of emerging technology for tracking and detecting infringement, e.g., content ID systems. 4. Public education campaigns, launch media literacy programs and campaigns to raise awareness of the value of IP as well as the effect of infringements. 5. Proactive and decisive creatives. Creatives who enforced their rights before the courts have often obtained redress. 6. Creatives must seek the assistance of seasoned IP lawyers for advice and assistance with the protection and enforcement of their rights. Conclusion. Ghana and Nigeria stand at the crossroads of a rapidly evolving digital landscape and growing creative economies. While the digital age presents new opportunities for cultural expression and economic growth, it also demands stronger copyright protection frameworks, coordinated legal reforms, public engagement, tailored and effective enforcement structures, and some regional cooperation to protect creatives and ensure the sustainability of Africa's burgeoning creative industries.
Page 12. Advertisement. Business of IP Asia Forum. 4th and 5th of December 2025 in Hong Kong. Leverage IP to finance business growth. www.bipasiaforum.com.
Page 13. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. The legal uncertainty behind viral fan edits. Stand First, Michelle S. Katz, founding partner at Advitum IP LLC, explores the complex landscape of copyright law as it relates to the burgeoning trend of fan edits on social media. As we move further into the digital age, with growing cult followings of TV shows and movies, individuals on social media platforms can share different types of media about screen media with little to no checks and balances. Specifically, young people have trended towards remixing or editing their favorite shows to evoke emotion, connect with other fans, and express appreciation for certain types of content. Taking creative liberties is a big part of the editing process. However, does this process fall under fair use, or should producers, writers, and studios act against these fans? The Urban Dictionary defines editing as composing a video filled with scenes and/or pictures, using transitions and effects. Individuals who edit movies and TV shows can do so by downloading scene packs, which is fandom slang for a curated collection of scenes from a larger work, which are used to make fan edits, according to the Scene Pack Wiktionary. TikTok, X, and Instagram are all platforms where young adults, specifically teenagers, express their likes or dislikes for TV shows and movies. While in many cases, edits of these types of media grow the popularity of copyrighted works, we must also consider the downside for creators when individuals remix their work without permission. Consider that to remix a song, one must gain permission from the songwriter. Is every teenager on TikTok who creates fan edits of their favorite show getting permission from writers and producers before posting? It's unlikely. If remixing a song is considered a derivative work, does that transfer to an edit of a TV show or movie? If the editor adds effects and music, is it fair use, or are users on social media perhaps some of the worst infringers to date? To explore further, it is essential to consider the fair use exception, which allows a limited use of copyrighted material without permission from the copyright holder. These uses balance the ownership of the copyright with the public interest in the free flow of information and creativity. The 4 factors to determine whether fair use is present are: 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole, and 4. The effect of the use upon the potential market for the value of the copyrighted work. 17 U.S.C.S. Section 107. So, do fan edits fall under fair use? Courts often stress the importance of the first factor, purpose and character of the secondary use. ID. Accordingly, he more the appropriator is using the copied materials for new, transformative purposes, the more it serves copyright's goal of enriching public knowledge and the less likely it is that the appropriation will serve as a substitute for the original or its plausible derivatives, shrinking the protected market opportunities of the copyrighted work. Authors Guild v. Google, Incorporated. 804 F.3d 202, 214, Second Circle. CT. 2015. Transformative use is described as one that alters the first work with a new expression of meaning or message. Andy Warhol found. For the Visual Arts, Incorporated. V. Goldsmith, 598 U. S. 508, 511, S. CT. 2023. So, perhaps the answer to whether fan edits fall under fair use depends on the edit itself. Fan edits often include different music, effects, and patch scenes that are not chronological. Perhaps the additional elements constitute fair use because of the transformative nature of the new work. In Authors Guild, the court held that the use at issue was non-infringing because the copying was highly transformative, and the work did not provide a significant market substitute for the protected aspects of the originals. Authors Guild 804 F.3d 202 at 229. If edits are found to violate copyrights, can owners enforce their rights? As it stands, social media platforms are all but overrun with fan edits. Is it worth the time and energy for production companies and writers to chase after everyone who creates fan edits? Perhaps the owners of these copyrights have found that, like in the Authors Guild, Fan edits are not a significant market substitute, and may even broaden the reach of some works. His form of marketing is undoubtedly a big success with TikTok users Caitlin Castillo, Gen Z's fascination with video edits, Bertex Orange, June 5, 2024. In many cases, these edits will reach more individuals than classic marketing techniques can, broadening the original work's audience. Social media platforms have become all but saturated with fan edits. As such, it is difficult to determine whether copyright holders will be successful in enforcing their rights against every single person who is using their protected materials. Though studios can act against specific fan edits, they usually do not because of the sheer volume posted to social media. In a digital landscape flooded with fan-made content, the question is no longer whether studios can enforce their rights, but instead, whether it's even worth it. Acknowledgement is extended to Sophie Gerfinkel, law clerk, for her valuable assistance in conducting research for this article. Page 15. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. What's hot in China's trademark practice? Stand First, written by Jimmy Huang, head of trademarks, and Yang Zhong, partner at AIPPI, China. The Chinese market is critical for many foreign brand owners, whether for distribution, sourcing, or both. But brand protection in China is often a complex, costly, unpredictable, and ultimately frustrating exercise. Staying updated on what's hot in China's trademark practice, the latest developments and best practices, is therefore key to navigating these challenges more effectively and reducing frustrations. Why register brands in China? Securing registrations in China offers the most cost-effective way for brand owners to preempt pirate filings and reduce the risk of enforcement against their goods. Registrations also provide effective infringement remedies, ranging from criminal, civil, and administrative enforcement to customs seizures and online takedowns. Without registrations, brand owners are left to rely solely on unfair competition claims, which can be expensive, slow, and unpredictable. Meanwhile, brand owners manufacturing in China face growing pressure from factory suppliers to record their trademarks with Chinese customs. Doing so allows authorized suppliers and exporters to be whitelisted, thereby preventing costly export delays caused by inadvertent seizures of legitimate goods. However, only trademarks that are registered in China may be recorded with customs. Further, major Chinese e-commerce platforms generally require evidence that a trademark is registered in China as a prerequisite for establishing branded flagship stores. Filing via Madrid versus filing directly in China. Filing through Madrid is the default strategy for foreign companies seeking to minimize filing costs. But there are hidden risks in relying on Madrid, and the most critical is the longer timeline for securing enforceable rights. For a direct filing, assuming the application does not encounter office actions or oppositions, the China National IP Administration, CNIPA, will typically issue a registration certificate within 8 to 9 months of filing. By contrast, for marks filed through Madrid, registration is technically retroactive to the date of extension to China. However, in order to actually enforce rights, the brand owner must secure a certification document from CNIPA confirming the validity of the extension, and this can only be obtained 19 to 20 months from the extension date. The discrepancy is mainly due to a CNIPA policy prohibiting trademark owners from requesting certifications until 18 months have passed from the extension date. The CNIPA certification document is specifically required to support applications to online trade platforms for takedowns, customs recordal, as well as civil, administrative, and criminal enforcement actions. Another potential drawback of filing through Madrid is that the specifications of Madrid applications are not tailored to China's subclass system. This frequently results in misclassification of goods, services, and significant gaps in protection that can undermine enforcement efforts and create opportunities for registry pirates. It is advisable to audit Madrid applications and assess whether additional filings in China are needed to obtain appropriate protection. Chinese language trademarks. Chinese consumers rely primarily on Chinese language brands to identify products. Brand owners that delay developing, using, and registering Chinese language marks often discover that local distributors or the media have created unofficial Chinese language names for the brand. Worse, these unofficial names frequently end up being registered by pirates, including commercial partners, who then demand huge payouts to transfer rights to brand owners. Given these risks, brand owners are advised to focus on Chinese trademarks early, including by researching whether any Chinese nicknames for their brands are already in use in the market. When devising and registering Chinese language brands, the focus should be not only on mainland China, but also Hong Kong, Taiwan, and Macau, as each of these territories has a separate legal system and trademark registry. Unreasonable rejections and non-use cancellations. Beginning in 2023, CNIPA implemented an uncodified policy intended to reduce the number of trademark registrations in China, primarily by increasing citations and objections on absolute grounds, most frequently, that a mark is non-distinctive, descriptive, or liable to mislead or deceive consumers. Under this policy, the prospects of successfully overturning even patently unreasonable rejections on appeal are significantly less promising than in years prior. Meanwhile, the appeal board and courts now also routinely reject consent letters submitted to support appeals based on conflicts with prior marks. Consequently, where applications encounter citations, exploring non-use cancellations to remove these conflicts has become critical. To compound the challenges faced by trademark applicants, in 2024, CNIPA began imposing new requirements on petitioners in non-use cancellation actions. A petitioner may now be required to provide a declaration stating that the action has been filed in good faith and prove that a reasonable online use survey has been conducted. For now, CNIPA continues to allow proxy petitioners, but subject to disclosure of the identity of the client and provision of a valid reason for using a proxy. Nevertheless, where the risk of retaliation is low, brand owners will normally be advised to file in their own names to mitigate the risk of triggering office actions. Bad faith registration. Following the 2019 amendment to the PRC trademark law, Chinese authorities introduced a range of measures designed to combat bad faith registrations, including automatic rejection of applications filed by blacklisted applicants, administrative fines against bad faith filers and their trademark agents, and reduced evidentiary burdens for victim brand owners proving bad faith. The 2023 draft amendment to the PRC trademark law further protects victim brand owners by allowing authorities to order the transfer of pirated marks to the rightful owner and, in especially serious cases, to impose criminal sanctions. However, the timeline for the enactment of these changes remains uncertain. Alongside these legislative developments, since 2018, Chinese courts have issued at least 22 positive decisions under the anti-unfair competition law of the PRC, AUCL, most of which resulted in significant compensation awards. Notably, 2 Chinese courts have imposed liability for unfair competition against infringers based solely, or nearly so, on their filing behavior, without evidence that the defendants had used the pirated marks in a substantial manner or sought to enforce their registrations against the plaintiff or its distributors. The courts have made clear in most cases that the compensation covers the plaintiff's legal and other costs incurred in dealing with registry actions, particularly oppositions and invalidation actions. Some courts have granted even more aggressive forms of relief, holding pirates' trademark attorneys jointly and severally liable based upon contributory liability, or ordering pirates to deregister registrations or withdraw applications for pirate marks. Despite inconsistent judicial standards across courts, civil remedies remain available in the longer term, as evidenced by the 2023 draft amendment to the PRC trademark law, which explicitly recognizes the right of victim brand owners to seek compensation from bad faith filers. Consequently, where the risks from bad faith filers are substantial, brand owners should evaluate whether to take actions beyond oppositions and invalidations. Such actions might include commissioning investigations to gather persuasive evidence of bad faith, as well as evidence of the scope and scale of any infringing trademark usage by the pirate. Issuing cease and desist letters to the pirate and its trademark agent. Filing complaints with CNIPA and local market supervision bureaus, MSBs, which have the authority to conduct their own investigations and impose administrative sanctions against pirates and their trademark agents. Filing a civil action at an earlier stage of the dispute, targeting not only the pirate but also their trademark agent. Seeking relief that includes I. compensation for all documented legal and investigation costs, and 2. a court order for the deregistration or withdrawal of pirated registrations and applications. Strategically selecting a venue where bad faith filing has already been recognized as a form of unfair competition, and where judges tend to encourage rapid settlement during pre-trial mediation proceedings. Trademark enforcement. Online enforcement remains a significant challenge for foreign brands in China. To date, local MSBs have limited their online enforcement efforts to pushing platforms to implement credible takedown systems, and they generally reject complaints against specific online sellers unless the case also involves commercial quantities of counterfeits in warehouses, factories, or retail outlets. This forces brand owners to either invest substantial resources tracing the sources of counterfeits advertised online or limit enforcement to takedowns and canned DS. As online enforcement technologies continue to evolve, brand owners are advised to adopt and utilize these services strategically and in line with the prevailing best practices outlined below. Operate integrated online enforcement programs that identify priority targets and enable swift decisions on sample purchases and online to offline investigations into the source. Such programs typically require close cooperation among in-house teams, external counsel, online service providers, and investigators. Kick off programs with comprehensive infringement surveys, followed by sample purchases to achieve a clearer understanding of the nature and scale of the problem and identify priority targets warranting more traditional enforcement measures. Generate reports incorporating periodic surveys and enforcement results to lobby platforms and enforcement authorities for proactive policing of the affected brands. Engage platforms in a friendly but firm manner, emphasizing ongoing close monitoring and accountability for failure to provide reasonable assistance. Pursue active criminal, civil, and administrative enforcement against high-profile sellers and their supply networks. Press investigators, platforms, and enforcement authorities to prioritize efforts to identify such networks. If appropriate, seek participation in local MSB's pilot programs, initiatives launched in certain cities with a limited number of brand owners to test new ways of leveraging administrative enforcement against online sellers. Conduct online sweeps and takedown work on a more tailored basis, e.g., by focusing mainly on more significant sellers and repeat offenders. Create benchmarks and KPIs that are realistic and more easily verifiable, e.g., including criminal, civil, and administrative actions that were successfully conducted on the back of online monitoring. Explore collaboration with competitors and other brand owners that are victims of infringement by the same seller networks. Notwithstanding these online challenges, authorities have progressively strengthened offline enforcement mechanisms. In most regions of concern, criminal enforcement has become significantly more accessible due to enhanced professionalism and motivation among local police handling IP cases. In 2024, local courts issued criminal sentences in over 10,000 cases, roughly double compared to 2019. Chinese police, prosecutors, and courts are increasingly relying on procedures akin to plea bargaining, which incentivizes infringers to proactively offer reasonable compensation to victim brand owners as a means of ensuring more lenient criminal sentences. The civil enforcement landscape in China has likewise become substantially more favorable to brand owners over the past decade. Courts now award considerably higher damages, while recoveries have become more predictable in recent years due to the implementation of the social credit penalty system, which imposes penalties against legal representatives of companies that fail to pay court-awarded compensation. Litigation counsel can typically estimate the level of compensation that Chinese courts will award in a given case, thereby further helping to increase predictability and facilitate decisions as to whether to pursue civil actions in particular cases.
Page 19. Advertisement. AIPLA 2025 Annual Meeting. We are back in Washington, D.C. this year. The Westin D.C. Downtown, October 30th and November 1st, 2025. Join over 1,500 IP professionals from around the world for 3 days of networking and education. Visit www.aipla.org/events.
Page 20. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Landlord liability in trademark infringement cases in Peru. Stand first, Adriana Barrera, founder and managing partner at Barrera and Asociados in Peru, explores the emerging legal responsibilities of landlords in trademark infringement cases within the Peruvian context. A landlord can be held liable for trademark infringement committed by tenants. They can be considered a contributory infringer if they knew, or should have known, of the infringing activity committed on their premises, and have not taken any measures or reasonable steps to stop it. Landlord liability is an extended doctrine in common law, particularly in the US. However, it is a relatively new legal concept in Peru, with legislation on the matter introduced shortly before the pandemic. The applicable legal framework is found in Provision 115 of Legislative Decree 1075, which grants the Peruvian Trademark Office, hereinafter PTO, investigatory powers, including the authority to Article 115 Investigation faculties. D. Require individuals or legal entities, as well as public or private, state or non-state, profit or non-profit entities, to adopt any measure that allows the preservation, permanence and integrity of documents, proceedings and assets under investigation and the collaboration that may be necessary for the exercise of their functions. E. Require, by means of a precautionary measure or resolution that ends a proceeding, to individuals or legal entities, as well as public or private, state or non-state, profit or non-profit entities, the adoption of measures that prevent the continuation or perpetration of acts practiced by third parties that involve the unauthorized use of elements protected by industrial property. Based on this provision, PTO may order the landlord or any other contributory infringer to take certain actions, such as disclosing the identity of the tenants, direct infringers, reporting the specific commercial activities conducted within their premises, publicly informing the manufacturer, storage, distribution, or seller of the counterfeit products that it is forbidden. PTO may order directing the landlord to implement the following precautionary imperative measures. Prepare and publish, in physical and online sites, warning signs regarding the illegality of using commercial establishments to manufacture, distribute, sell, or store counterfeits. Report the relationship of the contributory infringer with the direct infringers, defendants. If the direct infringer is a tenant, defendant, the landlord is required to attach a copy of the current lease agreement signed with them. Implement the following precautionary exhortative measures. To report any suspicious activities that could involve the manufacturing or commercialization of products bearing the infringed trademark. A resolution clause must be included in lease contracts to address breaches of the obligation to use the premises for legal purposes. This clause should specify that a breach occurs in cases of manufacturing, storing, distributing, or selling counterfeit goods. To establish sanctions against tenants who store, manufacture, distribute, sell and offer goods with infringing trademarks. These precautionary measures may become definitive upon the conclusion of the action, obligating the landlord to comply. It is important to note that during the trademark infringement action, the landlord will not be held responsible for the direct infringement since it is not a defendant but rather a facilitator or contributor of the infringement. However, if the landlord fails to comply with the measures or does not take steps to prevent further infringement, the PTO may initiate a non-compliance proceeding against the landlord. This could lead to a civil action to seek damages, which would be the responsibility of the landlord. Some of the benefits that brand owners may obtain by including landlord liability in trademark infringement cases include: 1. Disruption of infringement. By holding the landlord liable, the trademark holder can compel them to take preventive measures to stop the use of properties for the manufacture, distribution, sale or storage of counterfeit goods. This helps to effectively halt the infringement by addressing the source of illegal activity. 2. Visibility and awareness. Measures that require the posting of warning signs, both physically and online, increase the visibility of the issue and alert other potential infringers about the legal consequences of their actions. This can have a deterrent effect on other possible infringers. 3. Information gathering. Requiring the landlord to provide copies of lease agreements and other relevant information can help the trademark holder identify the infringers involved, as well as the networks and connections facilitating the infringement. This information can be crucial for building a strong case against the actual infringers. 4. Landlord accountability. If the landlord fails to comply with the required measures, they may face non-compliance proceedings that could include civil actions for damages. This added pressure can force the landlord to act more diligently to prevent infringing activities. 5. Improved law enforcement. Taking action against landlords can help enhance the enforcement of industrial property laws in general. Previous experiences in other jurisdictions have shown that such actions can strengthen the legal framework by setting precedents and promoting greater accountability among property owners. 6. Brand protection. In the long term, these actions can protect the integrity and reputation of the brand by reducing the presence of counterfeit products in the market. This contributes to consumer confidence and brand value. 7. Deterrence of illegal activities. Holding landlords accountable sets a precedent that discourages participation in illegal activities related to counterfeiting and unauthorized trade.
Page 22. Advertisements. Women's IP World 2026. Join the 7th annual edition of Women's IP World. Profiles, accolades, experience, articles, ranking, achievements. Inquire now to be a part of the IP industry's leading annual publication, celebrating the remarkable contributions and successes of women in the field of IP law and innovation. Contact us to join now. Visit website www.womensipworld.com. Call +44 0203 818 0457. Email us at info@womensipworld.com.
Page 23. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. CNIPA's latest regulatory updates on 3-year non-use cancellation applications, the equilibrium between procedural rigor and rationality. Stand first, Robert Chan and Yura Wang from Sun & Chan Intellectual Property Company, Limited. Discuss the recent regulatory updates by the China National Intellectual Property Administration, CNIPA, on 3-year non-use cancellation applications following significant reforms aimed at alleviating the burdens on applicants. The latest requirements on 3-year non-use cancellation applications introduced by the China National Intellectual Property Administration, CNIPA, at the latest symposium at the end of this June, 2025, marked the second reform of such applications this year. The reform issued at the start of this year undoubtedly imposed a substantial impact on applicants, increasing the burden of proof and sparking questions about the necessity of certain evidence. However, the conclusions drawn from the latest seminar are certain to bring a sigh of relief to applicants and their agents, as both process standardization and the rationality of evidence requirements have been elevated to a new level. Legal basis for non-use cancellation in China. Under Article 49(2) of the China Trademark Law, any registered trademark that remains unused for 3 consecutive years without justifiable reasons may be subject to cancellation upon application by any party. This framework is designed to remove idle trademarks from the register and free up resources for active brand owners. 1. New amendments introduced at the end of June 2025. The following 3 documents will no longer be required for non-use cancellation applications. Letter of commitment. Trademark registration portfolio of the trademark registrant. On-site evidence investigations of the trademark registrant. 2. Proving non-use of a service trademark. The CNIPA interpreted that for service trademarks, e.g., Class 35, the applicant could retrieve the right holder's basic commercial information first. If such information does not include service items, non-use may be presumed. 3. On identifying malicious non-use cancellation applications. In the current exploratory phase, malicious intent will not be easily determined. However, applications may be deemed malicious if the applicant files an excessive number of non-use cancellation applications. The applicant files a non-use cancellation application knowing the mark is in use. The applicant repeatedly files non-use cancellation applications against the same mark. Examiners will re-review the case. If evidence of use is found or it is known that the mark is in use, repeated applications would be rejected. A trademark agency handles both the registration of Mark A and a non-use cancellation application against Mark A by Party B. Other situations where the application clearly violates the principle of good faith. 4. Filing a non-use cancellation application by a natural person or a third party. At the time of the last change in requirements, if the non-use cancellation application is filed in a non-related party's name, the CNIPA may reject the filing due to the absence of reasonable and true grounds. While based on the latest modified requirements, natural persons are not categorically barred from filing non-use cancellation applications, and the applicants no longer bear the obligation to disclose related cases since the examiners will independently retrieve related case information. In other words, a non-use cancellation application filed by a non-related party, natural person or organization, is now acceptable according to the latest regulations introduced by the CNIPA. However, the CNIPA also requires that any non-use cancellation application shall be filed in a fact-based and responsible manner. In case an amendment is required, the applicant should still submit a separate explanation to CNIPA to advise of the relationship between the straw man and the applicant, or its connection to a specific case. 5. Querying goods or services for cancellation when the list is extensive. Previously, evidence for each designated item was required. But the CNIPA, at the latest symposium, clarified that querying a few representative items would be sufficient if the evidence provided could credibly prove the fact that the subject trademark has not been used. 6. Searching for purely graphic marks. Evidence investigation for graphic marks must start with the right holder. First, verify whether the entity engages in commercial activities. Then search e-commerce platforms for storefronts. Use AI-powered search software supplemented by other platforms. For marks used in offline settings, e.g., a breakfast bun shop in a residential area, utilize review platforms like Dazhong Dianping, a popular review platform in China, or Meituan App, a popular food delivery platform in China. 7. The CNIPA is developing a template rationale statement to standardize formatting and evidentiary requirements for a non-use cancellation application. Key takeaway. 2 reforms in half a year. This represents a proactive attempt by the CNIPA to continuously explore the equilibrium between procedural rigor and rationality. Although malicious non-use cancellation applications may increase enforcement costs and burden examination resources, streamlining non-use cancellation applications procedures could also indirectly encourage active, legitimate, and reasonable mark use. Page 25. Segment. Behind the brief. A closer look at the people powering IP law around the world. A closer look at the people powering IP law around the world. In the ever-evolving world of intellectual property, legal professionals stand at the forefront, safeguarding innovation, protecting creative works, and shaping the legal frameworks that underpin global commerce and technological progress. Behind the brief is a dedicated segment that shines a spotlight on the individuals and firms who are driving the future of IP law across borders. From seasoned IP litigators and patent experts to pioneering firms redefining strategy in trademark and copyright protection, this series goes beyond the courtroom to reveal the stories, motivations, and milestones of the people behind the practice. Each profile offers a unique insight into their journeys, landmark cases, leadership roles, and contributions to the advancement of IP law both locally and globally. Through Behind the Brief, we celebrate the legal minds who not only understand the value of ideas, but work tirelessly to protect them. Page 26. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Celebrating half a century of experience in IP, Dr. Tatiana Vaknina, Senior Partner and Founder of Vaknina and Partners. Stand first. In honor of Dr. Tatiana Vaknina's 80th birthday, Vaknina and Partners celebrate her remarkable contributions to the field of IP law and her enduring impact on the professional community. This August, Vaknina and Partners proudly celebrates a remarkable date, the 80th birthday of our esteemed senior partner and founder, Dr. Tatiana Vaknina. On this special occasion, we would like to take the opportunity to honor her outstanding contributions and reflect on the legacy of her distinguished career. For more than 50 years, Tatiana has played a pivotal role in shaping the development of IP property in Russia and the Eurasian region. A true pioneer and mentor, she has guided generations of attorneys and specialists, sharing her expertise, vision, and dedication to the profession. Tatyana was among the first Russian and Eurasian patent attorneys certified by the Russian and Eurasian Patent Office, Russian Patent and Trademark Attorney No. 122, and Eurasian Patent Attorney No. 38. For numerous merits for the development of the Institute of Intellectual Property, Tatyana received the esteemed title Honorary Advocate of the Russian Federation. Throughout her distinguished career, Tatyana has been an active member of many Russian and international organizations, including the Chamber of Patent Attorneys of the Russian Federation and the Eurasian Assembly of Patent Attorneys. Her commitment to the development of IP is reflected in her active participation in leading professional associations such as INTA, AIPPI, LACI, ECTA, Marques, PTMG, APAA, etc. Tatyana has earned a reputation as one of the most respected patent and trademark attorneys and advocates in the Russian Federation, consistently supporting the effective registration and protection of IP rights. Over the past 40 years, Tatyana has been recognized as a leading specialist in the field of IP in Russia by all leading ratings, such as Chambers Global, Legal 500, Managing IP, Best Lawyers, Who's Who Legal, WTR 1000, IM Patent 1000, ICFM 500 Leading Lawyer, Manda Awards, ACQ5, and many others. A number of international publications such as Chambers Global, the world's leading lawyers for business, Managing Intellectual Property, Expert Guides, Who's Who Legal, Which Lawyer? Legal 500, The Best Lawyers, and other respected rankings and magazines have nominated Tatyana into their top lists of selected specialist individuals in the practice area of IP in Russia for more than 2 decades. Tatyana and our company are especially proud of the nominations and victories in the ratings of companies related to the protection of women's rights. Vaknina and Partners has been repeatedly noted in various surveys and ratings, and by colleagues from different countries, as a team in which all department heads, including the senior partner, are women, and in which the majority of the team are women. Vaknina and Partners has been repeatedly recognized as the best company for women to work in, according to surveys and ratings on diversity, a company that has created conditions for women to work, including women with young children, supporting special health insurance programs and remote work for employees on maternity leave or employees with children. In recent years, Vaknina and Partners has demonstrated dynamic growth and confident development across Russia and the Eurasian region. By expanding the team with highly qualified professionals, adopting advanced approaches to IP protection, and reinforcing its presence in strategic jurisdictions, the firm has further strengthened its position as a trusted and forward-thinking IP partner both locally and internationally. Thanks to Tatyana's vision and leadership, the firm has cultivated a strong and reliable network of partners, agents, and representatives across many countries of the former USSR. This well-established infrastructure allows Vaknina and Partners to serve as a convenient one-stop shop for clients seeking IP services throughout the CIS, the Eurasian region, and beyond, in the following countries: the Republic of Armenia, the Republic of Belarus, the Republic of Kazakhstan, the Kyrgyz Republic, the Republic of Moldova, the Russian Federation, the Republic of Tajikistan, Turkmenistan, the Republic of Uzbekistan, the Republic of Georgia, the Republic of Mongolia. Over the past few years, Vaknina and Partners has opened offices in several Eurasian countries, including the Republic of Armenia, office in Yerevan, and the Kyrgyz Republic, office in Bishkek, to help foreign clients in today's complex geopolitical conditions to actively enter the markets of Russia and Eurasia, register and maintain IP at the Eurasian Patent Office and in Russia, and simplify the mechanisms of paying for and maintaining patents and trademarks. The Vaknina and Partners team has been strengthened by experienced experts from the Patent Office, who joined the company's patent department in 2025, bringing with them deep institutional knowledge and invaluable expertise that contribute to the firm's continued growth and high professional standards. Our patent attorneys, lawyers, and specialists conduct a large number of patent searches and patent studies in various areas of patent law. Currently, the patent practice of Vaknina and Partners is headed by Dr. Elena Utkina, who is also head of the chemistry department, former deputy director of Rospatent's Federal Institute of Industrial Property. Utkina is one of Russia and Eurasia's strongest and most experienced lawyers in the field of pharmaceuticals, organic and inorganic chemistry, biochemistry, biotechnology, and medicine. Many large pharmaceutical corporations leverage the experience and knowledge of Vaknina and Partners' patent department to file applications in Eurasia and Russia, perform professional translations, renewals, and maintenance of IP in Russia, the Eurasian Patent Office, the countries of Eurasia, and the former USSR. Likewise, many international companies use the professional experience of Vaknina and Partners in the field of trademarks, entrusting filings and renewals in Russia and the countries in the Eurasian region. Re-registration of trademarks in Russia and Belarus is currently especially popular. Although many large international companies have temporarily suspended operations in Russia, they are planning to return to the Russian market soon. In 2025, many companies will reach the 3-year mark since ceasing official product supply or direct operations in Russia. Trademarks may become subject to cancellation due to 3 years of non-use. Therefore, many applicants prefer to refile their trademarks and well-known brands in Russia to avoid the possibility of trademark cancellation due to non-use. Vaknina and Partners help such clients conduct a quick check and audit of their trademarks, putting the most popular trademarks on monitoring, and quickly preparing and refiling clients' trademarks. For many years, Totyona and Vaknina and Partners have actively participated in many professional organizations and associations within Russia, the Eurasian region, and internationally. Totyona was one of the first patent attorney participants from Russia who began to take part in conferences in the 1990s, including INTA, AIPPI, FICPI, LACI, and others. Thanks to the active support of volunteer activities and the activities of professional organizations, for many years Vaknina and Partners has been a sponsor and co-organizer of many Russian, Eurasian, and international conferences, seminars, and webinars. After the challenging years of the COVID-19 pandemic, the FICPI management and president asked the members to sponsor this international organization. Vaknina and Partners was the first and only company to respond to this support request for FICPI, becoming the first sponsor in history in 2021. We hope that our modest participation helped FICPI maintain a high level of educational programs for specialists and patent attorneys. In June 2025, Vaknina and Partners acted as co-organizer and sponsor for the Eurasian Assembly of Patent Attorneys in Yerevan, Armenia. This conference brought together participants from 11 countries, including lawyers and attorneys from Armenia, Russia, Belarus, Georgia, the EU, and other countries. Totyona is confident that the Eurasian Assembly will succeed in creating a truly independent international organization, where there will be no place for restrictions and discrimination based on nationality, citizenship, or religion, and where all participants will be welcome. This is exactly what Totyona believes all modern organizations and associations in the field of IP should be, independent of politics, international events, and private opinions. We once again congratulate Totyona on her anniversary, and hope that her efforts and the efforts of her team will lead to strengthened friendship and cooperation between colleagues from different countries. This remarkable milestone, 80 years, is not only a celebration of longevity but a testament to a life dedicated to the advancement of IP law, international dialogue, and professional excellence. Totyona's contributions have left a significant mark on the development of the legal profession both in Russia and abroad. Her deep expertise, commitment to mentorship, and tireless work in building international partnerships have earned her respect and admiration worldwide. Throughout her distinguished career, Totyona has exemplified the highest standards of integrity, leadership, and service. Her ability to unite professionals across borders, to nurture talent in the next generation of specialists, and to remain a steadfast advocate for the value of global cooperation continues to inspire. As we celebrate this important occasion, we extend our sincere appreciation and heartfelt congratulations. May Totyona's passion and vision continue to guide and motivate the professional community for many years to come.
Page 28. Advertisements. Women's IP World Ranking 2026. Invitation to be part of the top 100 influential women leaders in IP law. Champions of Leadership, Innovation, and Global Influence 2026 ranking. Submit your nomination today, put forward a colleague, or share the link with deserving industry friends and leaders. Nominations are open and completely free to enter. The deadline to submit ranking nominations is October 31st, 2025, at 5 p.m. GMT. Visit www.women'sipworld.com/WIPW-ranking-2026. Call +44 0203 818 0457. Email us at info@women'sipworld.com.
Page 29. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Understanding Compulsory Licensing, A Sri Lankan Perspective. Stand First, Anomi Wanigasekara, Senior Partner at Julius & Creasy, explores the implications and significance of compulsory licensing within the context of Sri Lanka's legal and economic framework. A patent is an IP right which encourages the development of innovations and technologies in different fields, such as engineering, the chemical industry, the pharmaceutical industry, biotechnology, etc., due to the protection it offers to the rights holder. A patent is granted by the government to the inventor, granting permission to exclusively make, use and sell the invention upon disclosure for a limited period. Patents are territorial in nature. Inventions can be protected by patents provided the invention is novel, involves an inventive step and is industrially applicable. Sri Lanka is a contracting state to the Paris Convention, Patent Cooperation Treaty, and the TRIPS Agreement. In 2003, the law was amended to be in line with TRIPS provisions, and the Intellectual Property Act No. 36 of 2003, IP Act, came into force. Part 4 of the current IP Act refers to the law relating to patents. An invention has been defined as an idea of an inventor, which permits, in practice, the solution to a specific problem in the field of technology. Both product and process patents are recognized in Sri Lanka and are valid for a period of 20 years, during which the patent owner can exploit their rights. Rights conferred by patent protection. During the period of protection, the owner of a patent is entitled to the following exclusive rights: 1. Exploitation of the patent, 2. Assignment or transmission of the patent, and 3. Conclusion of license contracts. Limitation of rights. Protection does not extend to acts done solely for the purpose of scientific research, or protection is limited to acts done for industrial or commercial purposes. Protection must not preclude licensees or any person who, prior to the filing or priority date of the patent application, was in good faith making the product, using the process in Sri Lanka, which is the subject of a patent, or has in good faith made serious preparations in Sri Lanka towards making the same. Protection does not extend to the presence or use of products on foreign vessels, aircraft, spacecraft, or land vehicles that temporarily or accidentally enter the waters, airspace or territory of Sri Lanka. Protection must not extend to acts in respect of articles that have been put in the market by the owner of the patent, or by a manufacturer under license, exhaustion or rights. Protection is subject to the provisions on compulsory licensing. Compulsory licensing. Compulsory licensing refers to a legal mechanism where, under IP law, the government allows a third party to produce a patented product or process without the consent of the patent owner. This is one of the flexibilities in the field of patent protection included in the trade-related aspects of intellectual property agreement. TRIPS. The TRIPS agreement protects patents, including those applicable to new diagnostics, vaccines, medicines, and medical supplies. TRIPS have 164 member states, and patent protection clauses are binding either directly or by incorporation into the respective statutes in the member states. Doha Declaration on TRIPS and Public Health acknowledges the need to balance the patent protection system with a compulsory licensing system. However, as per Article 31 of the TRIPS Agreement, it is necessary to consult and negotiate with the patent owner before compulsory licensing and manufacturing of a drug can take place. Although patent protection is in the hands of the patent owner, states may have the right to use them in the case of emergencies, and many countries have their own laws to facilitate such arrangements. The IP Act of Sri Lanka provides for compulsory licensing, 1, where a party has made efforts to obtain approval from the right holder on reasonable commercial terms and conditions and that such efforts have not been successful within a reasonable period of time, 2, where a national emergency or any other circumstances of extreme urgency or in case of public non-commercial use for the purposes such as national security, nutrition, health, or for the development of others vital section of the national economy, and 3. For the exploitation of a patent, the second patent, which cannot be exploited without infringing another patent, the first patent. The conditions under which compulsory licenses are granted are as follows. Limited in scope and duration for the purpose as specified in the license. Predominantly for the purpose of supply to the domestic market. Non-exclusive and subject to the payment of adequate remuneration to the owner of the patent. Where exploitation of a patent, second, results in infringement of another, first, the second patent shall involve an important technical advance of considerable economic significance in relation to the invention claimed in the first patent, the owner of the first patent. While Sri Lanka has not yet exercised compulsory licensing for healthcare drugs, the legal framework exists under the IP Act as aforesaid. It is considered a potential tool during health emergencies, especially for improving access to essential medicines. Countries like India and Thailand have used compulsory licensing to improve access to medicines. In emergency situations, compulsory licensing balances patent rights with public health needs, lowers the price of drugs, and encourages local drug manufacture, which helps treat the public on a larger scale. Page 31. Article. Disclaimer. Images and references related to this article can only be seen in the print and digital versions of the magazine. The Power of Patent Data in Research and Business Strategy. Stand first. In today's fast-paced innovation landscape, Kenichi Nakajima, Senior Manager of IP Service and IP Analytics, Clarivate, Japan, highlights how leveraging patent data can transform research and business strategies, unlocking invaluable insights that drive competitive advantage and foster collaboration. As innovation cycles accelerate and global competition intensifies, the ability to extract strategic insight from patent data is becoming a defining capability, separating organizations that shape the future from those that struggle to keep pace. The evolving landscape of patent data. Over the past 2 decades, patent data has evolved from a niche legal resource into a strategic asset for organizations navigating increasingly complex innovation landscapes. This shift has been driven by the digitization of global patent records, advances in data structuring, and the emergence of analytics platforms capable of turning millions of documents into actionable insight. Today, patent databases are more than legal archives. They are dynamic knowledge systems that reflect the frontiers of technological progress. For academic institutions, they offer visibility into global research trajectories. For corporations, they provide a lens on emerging technologies, competitive activity, and potential risks. This evolution is particularly relevant in Japan, where innovation is central to industrial strategy. Universities and research institutes are increasingly using patent analytics to support grant applications, demonstrate research impact, and identify collaborators as part of their technology transfer initiatives. Corporations, meanwhile, are embedding patent intelligence into broader business functions, from research and development, R&D, planning to merger and acquisition due diligence. Enabling this shift is the growing availability of enriched patent data. Modern platforms offer standardized abstracts, normalized legal status, and integrated litigation records, allowing users to move beyond basic keyword searches to more sophisticated forms of analysis. Whether mapping a technology landscape, assessing freedom to operate, or identifying licensing opportunities, organizations now have the tools to do so with greater clarity and confidence. 4 core approaches to patent analysis. Patent data holds untapped strategic value. When approached strategically, it can reveal patterns, opportunities, and risks that might be invisible to traditional market or scientific research. Academic institutions and corporations alike are increasingly applying structured methodologies to extract insight from patent records. 4 core approaches have emerged as particularly effective. 1. Technology trend analysis. This approach maps the evolution of technologies across geographies, organizations, and inventors. By analyzing patent filing volumes, citation networks, and thematic clusters, researchers can benchmark innovation activity, identify emerging fields, and assess competitive positioning. For instance, a research institute could use a trend analysis to highlight its leadership in a specific domain, such as advanced materials or quantum computing, when applying for public funding or seeking industry partnerships. Similarly, corporations might use this method to monitor competitor R&D strategies or anticipate shifts in innovation focus across global markets. 2. New application discovery. Patent abstracts often contain clues about an invention's intended use and technical features. By applying text mining and machine learning to these abstracts, analysts can uncover novel applications for existing technologies, sometimes in entirely different industries. A company exploring diversification opportunities, for example, might identify that a sensor technology originally developed for automotive safety could also be adapted for medical diagnostics based on overlapping functional descriptors found in unrelated patent families. 3. Collaboration mapping. Innovation is increasingly collaborative. Evaluating the patents of research institutions from both qualitative and quantitative perspectives can help identify potential partners for companies. Citation analysis from patent to literature also helps identify potential licenses for academia. Academic institutions might use this approach to identify industry collaborators for joint research projects, while corporations could apply it to scout acquisition targets or licensing opportunities. In Japan, where cross-sector innovation is a national priority, collaboration mapping can support the formation of strategic alliances that align with national and regional innovation goals. 4. Internal technology inventory. Large organizations often struggle to maintain visibility across their own innovation landscape due to the dynamic, evolving nature of research. Patent analytics can help map internal strengths by clustering patents by technology domain, inventor, or business unit. For example, a multinational could use this method to uncover underleveraged capabilities in one division, such as robotics expertise within a consumer electronics team, leading to new product development or cross-functional innovation initiatives. Methodologies and tools behind patent analysis. Effective patent analysis relies not only on access to data but also on the methodologies used to interpret it. The quality of insights drawn from patent records depends on how well the data is structured, the analytical techniques applied, and the expertise of those conducting the analysis. As AI-based patent search tools evolve, understanding the methodologies behind patent analysis becomes even more important. Structured patent abstracts are a critical input. When enriched with metadata, such as inventor affiliations, technology classifications, and legal status, they support text mining, semantic clustering, and trend detection. These abstracts improve search precision and reduce noise, enabling more targeted Boolean and AI-based natural language queries. A key differentiator in high-quality datasets is the presence of manually curated content. Abstracts authored by subject matter experts, such as those found in the Derwent World Patents Index, DWPI, offer consistent terminology and clearly defined novelty, use, and advantage fields. This level of detail enhances classification accuracy and supports cross-jurisdictional comparison. Beyond textual analysis, network-based methodologies add further depth. Citation analysis can reveal knowledge flows between technologies or institutions. Co-inventor networks highlight collaboration clusters, while normalized applicant codes help identify entities that may be obscured by inconsistent naming, particularly useful when evaluating small and medium-sized enterprises for partnership or acquisition. Tools vary in depth and usability, depending on the analyst's needs. Some prioritize simplicity, while others offer advanced capabilities such as customizable search templates, access to hundreds of searchable fields, and integrated litigation data to support complex use cases like freedom to operate, FTO, or invalidity assessments. Ultimately, the effectiveness of any patent analysis depends on aligning the tool's capabilities with the user's objectives. Whether supporting academic research, guiding strategic investment, or informing policy decisions, the combination of enriched data, robust methodology, and domain expertise remains essential. Looking ahead, the role of patent data in strategic decision-making. Patent analytics are rapidly becoming a key differentiator in innovation performance. No longer confined to IP departments, patent data is now recognized across academia and corporate strategy as a foundational resource for evidence-based decision-making. As organizations navigate increasingly complex global markets, patent intelligence offers a way to anticipate technological shifts, identify emerging competitors, and uncover new opportunities for collaboration or investment. In academic settings, it supports research impact assessments, curriculum development, and interdisciplinary initiatives. In industry, it informs decisions ranging from R&D prioritization to licensing strategy and MANDA due diligence. The expansion of use cases, from prior art searches to partner discovery, market expansion, and portfolio optimization, signals a shift toward patent data as a multipurpose intelligence asset. This trend is likely to accelerate as analytics platforms become more integrated, combining patent data with scientific literature, regulatory filings, and market insights to provide a holistic view of innovation ecosystems. Looking ahead, the challenge will be not just accessing patent data but embedding it meaningfully into decision-making processes, ensuring that insights derived from IP align with broader strategic goals and drive measurable impact. Visit Clarivate.com Derwent to explore how enriched patent data and advanced analytics can support your organization's strategic goals, from research planning to innovation management.
Page 33. Advertisement. International Intellectual Property Law Association. AIPPA 2025 USA. September 20th and 30th, 2025. El Prado Hotel, Palo Alto, California, USA. Register now. AIPPA 2026 Dubai. January 19th and 20th, 2026. Radisson Blu Hotel, Dubai Waterfront. Register now. Mail at IIPLA.org. Page 34. Advertisement. Gorodisky. Intellectual Property TMT. www.gorodisky.com.
Page 35. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Legal aspects of compulsory licensing in the pharmaceutical sector in Russia. Standfirst, Yevgeny Alexandrov, senior partner at Gorodisky and Partners, explores the complex legal landscape of compulsory licensing in Russia's pharmaceutical sector, highlighting its significance during public health crises and the interplay between IP rights and access to medicines. Compulsory licensing of pharmaceutical patents represents one of the most complex intersections of IP law, public health policy, and market economics. As a legal mechanism permitting third-party production of patented medicines without the patent holder's consent, it captures the fundamental tension between incentivizing innovation through patent protection and ensuring widespread access to essential therapies. Before the COVID-19 pandemic, Russia had never used compulsory licensing. Though both international and Russian law allow for such measures, they remained unused until the unprecedented crisis caused by the virus. When deaths skyrocketed daily, the government had no choice but to take drastic measures, including compulsory licensing, to ensure access to essential medicines. In these specific cases, Russia resorted to compulsory licensing as a last resort to guarantee availability of critical medications. Each compulsory license was issued with a limited duration. Basically, the Russian legislation envisages two types of compulsory licensing, CL. As a non-exclusive license which may be granted based on a court decision in case of non-use or insufficient use of an invention, or in case of patent dependency, or as a permission granted by the government to a selected manufacturer in cases of extreme necessity related to ensuring the defense and security of the state, protecting the lives and health of citizens, or for exporting to another state in accordance with an international treaty. In recent years, the issue has grown more urgent in Russia as several international pharmaceutical companies have withdrawn from the Russian market, creating risks of drug shortages and jeopardizing the availability of modern treatments. This exodus stems from various geopolitical and economic factors, leaving critical gaps in the supply chain. Concurrently, Russian generic manufacturers have intensified their efforts, initiating court proceedings to acquire compulsory licenses for patented inventions protecting original medications. Between 2022 and 2025, the number of intellectual property disputes in Russia's pharmaceutical sector doubled compared to the previous 5-year period, 2017 to 2021, reaching a total of 100 cases over 7 years. These disputes include patent validity, patent infringement, and compulsory licensing cases initiated by a few local generic companies. International framework. The concept of compulsory licensing is not new and has roots in international IP treaties to which Russia is a party. The Paris Convention, 1883, was among the first international agreements to recognize the possibility of compulsory licensing as a measure to prevent abuses of patent rights. Article 5A(2) of the Convention explicitly allows member states to adopt legislative measures to grant compulsory licenses if the patent holder fails to work the invention locally or engages in anti-competitive practices. The TRIPS Agreement, adopted in 1994 as part of the WTO framework, further refined the rules governing compulsory licensing. Article 31 of TRIPS sets forth specific conditions that must be met for the issuance of a compulsory license. These provisions were designed to strike a balance between protecting intellectual property rights and addressing public health needs. The Doha Declaration on TRIPS and Public Health, 2001, reaffirmed this balance, explicitly stating that TRIPS should not prevent member states from taking measures to protect public health, including through compulsory licensing. Many countries have adopted special provisions in their patent laws regulating the issuance of compulsory licenses. The grounds for granting compulsory licenses vary depending on the position of each country and its legislation. For instance, European Union Regulation, EC, No. 816/2006 allows compulsory licensing for export to countries with public health problems, emphasizing proportionality and transparency. In May 2025, the European Union reached a political agreement to introduce a unified mechanism for compulsory licensing in emergency situations, which is expected to enter into force after formal approval by the European Parliament and the Council of the EU. The new mechanism will be activated only after an official declaration of a crisis at the European level, such as a pandemic outbreak or natural disaster. This measure is intended to facilitate rapid access to essential medicines and technologies. However, compulsory licensing in such cases is considered a measure of last resort and will be applied only after unsuccessful attempts to reach voluntary agreements with rights holders. This demonstrates that compulsory licensing is generally treated as an exceptional measure, reserved for situations where voluntary solutions are unattainable and public interest demands intervention. Legal framework in Russia. In Russia, the government is also focused on ensuring that the mechanism of compulsory licensing is applied only in cases of genuine threats to national defense, security, or the lives and health of citizens. To achieve this goal, pursuant to the Government Resolution No. 380 of March 27, 2024, a subcommission was established to address issues related to the use of inventions, utility models, and industrial designs. This subcommission establishes rules and principles for its operation, as well as a transparent procedure for processing applications and determining the grounds for granting permissions. Initially, an application must be submitted to the Ministry of Economic Development. If it meets the specified requirements, the ministry forwards it to the Ministry of Industry and Trade, the Federal Service for Intellectual Property, the Federal Anti-Monopoly Service, and the agency responsible for the relevant area of activity, such as the Ministry of Health or the Ministry of Defense. These agencies are required to submit conclusions on the application within their competence, indicating whether permission can or cannot be granted. Upon receiving these documents, the Ministry of Economic Development prepares a conclusion and makes a final decision on whether to grant permission. The emergence of the Subcommission on Compulsory Licensing in Russia marks a significant step forward in clearly defining the procedure and conditions for granting compulsory licenses. The new approach minimizes subjectivity and increases transparency, preventing arbitrary application of the compulsory licensing mechanism, thereby emphasizing its exclusively emergency nature. Meanwhile, although obtaining government permission can be a cumbersome process for generic companies, most prefer to pursue the court procedure, which allows them to claim a compulsory license to be granted under the legal provisions of Article 1362 of the Civil Code. This article outlines two specific grounds for granting a compulsory license: non-use or insufficient use of the invention, when the patent holder has not commercially exploited the invention in Russia for a period of 4 years from the patent grant, or where the patent holder's exploitation of the invention does not meet market demand, para 1 of Article 1362. Patent dependency. If a patent holder cannot use his invention without infringing another patent holder's rights and the latter refuses to grant a license on reasonable terms, para 2 of Article 1362. While non-use is relatively straightforward to determine, insufficient use introduces significant legal ambiguity. The law does not define what constitutes sufficient use, leaving courts to interpret this standard on a case-by-case basis. This has led to inconsistent rulings and created challenges for both patent holders and generic manufacturers seeking licenses. The lack of clear criteria for determining insufficient use has resulted in divergent judicial approaches. Some courts have relied on quantitative metrics, such as the volume of drugs supplied relative to the number of patients, while others have considered qualitative factors, such as the affordability and accessibility of the medication. For example, in a case No. 40185112/2022 handled by the Commercial Court of Moscow involving a patented drug, the court in 2023 ruled that the patent holder's failure to participate in all government tenders constituted insufficient use since the total number of the supplied drugs did not correspond to the registered number of patients with the particular disease. In this case, the court preferred to adopt an overly simplistic, and arguably misguided, approach, assessing drug demand based solely on statistical numbers of patients, then comparing these figures with market supply. However, this method is inherently flawed, as it fails to account for the nuanced needs of individual patients and the diverse treatment strategies used by medical professionals. Physicians tailor prescriptions to each patient, considering factors like age, concurrent health conditions, allergies, contraindications, and other individual circumstances. Clearly, even when many people suffer from the same disease, a one-size-fits-all medication approach is unrealistic. Moreover, multiple drugs may be effective for the same diagnosis, further complicating demand projections for any single pharmaceutical. Another ground for compulsory licensing occurs when the use of an invention is impossible without infringing the rights of another patent holder, dependency of patents. In such cases, the interested party has the right to seek a compulsory license in court if the original patent holder refuses to conclude a licensing agreement on reasonable terms. Significant conditions for granting a compulsory license under this ground include proving that the second invention represents a substantial technical achievement and provides noticeable economic advantages compared to the invention owned by the first patent holder. Russian judicial practice has already seen several cases involving this norm, such as the case A40-714717-110-675 and case A40-166505/2017. In these cases, courts concluded that all necessary conditions for issuing a compulsory license were present. However, some aspects remain controversial. For example, judges face the challenge of assessing the significance of the technical and economic advantages of the dependent invention, which often leads to difficulties and differences in judicial approaches. These rare cases highlight the challenges courts face when issuing compulsory licenses for the first time, as current decisions lack clear grounding. The main issue stems from the absence of explicit criteria in both national laws and international agreements. Solutions could involve updating legislation or developing case law through higher courts. With that, it is important to note that Russian legislation is largely harmonized with international agreements and corresponds to the legal regulation of many countries worldwide. This is not a unique problem for this specific jurisdiction, but rather a result of an absence of a general approach in international treaties with clear criteria for granting a compulsory license. Every country seeks its own approach. According to the AIPPI Compulsory License Summary Report Q293 SRP 2025, 80% of respondents advocate for further harmonization, pointing to inconsistencies in enforcement, remuneration, and procedural requirements across jurisdictions. Conclusion. Undoubtedly, compulsory licensing can be useful in extreme situations such as pandemics or natural disasters, where access to essential medicines becomes a matter of survival. The mechanism is designed to strike a delicate balance between honoring patent holders' rights and meeting urgent public health needs. However, its practical application raises significant challenges. Production of high-quality medicines is a complex process that transcends publicly available patent information. Crucially, it often depends on undisclosed trade secrets, such as proprietary manufacturing techniques or specialized equipment configurations, which are legally protected in Russia and cannot be subjected to compulsory licensing, unlike patents. The European Parliament and Council have also explicitly confirmed that rights holders will not be obligated to disclose their trade secrets when invoking the compulsory licensing mechanism. However, these hidden components are essential for reproducing patented drugs reliably and safely. Since compulsory licensing typically applies only to patents and does not extend to trade secrets, licensees may lack the necessary knowledge and expertise to produce effective substitutes. As a result, even if a compulsory license is granted, the quality and safety of the reproduced drug may be compromised. Instead of viewing compulsory licensing as a panacea, policymakers should focus on alternative approaches. One promising direction is voluntary licensing, where patent holders collaborate with governments or third parties to ensure broader access to life-saving treatments. This mechanism preserves patent holders' rights while addressing public health emergencies. Another feasible option is encouraging localization of production through partnerships between foreign companies and local manufacturers. Projects like SPIC, special investment contracts, in Russia aim to incentivize foreign firms to establish local facilities, thereby increasing self-sufficiency in essential medicines. In conclusion, compulsory licensing remains a valuable tool in times of crisis, but its application must be approached with great caution. Emphasizing voluntary agreements and localized production provides a more sustainable path forward, minimizing the risks associated with compulsory licensing while ensuring a healthier future for all. Protecting sensitive production stages as trade secrets may help maintain market balance and prevent unintended negative consequences. Page 39. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. From Milan to the Metaverse, Simona Lavagnini on IP law, innovation, and Italy's global role. Stand first. We sat down with Simona Lavagnini, founding partner at LGV Avvocati, Italy, to discuss key developments in IP law, from the impact of the Unitary Patent Court to challenges surrounding AI-generated content, brand protection, and cultural heritage. Here's what she shared with Northern's media reporter Zafira Hudani. Zafira: Simona, how does your firm assist clients in the area of life sciences? Simona: in this area, our firm deals with two kinds of activities. One is litigation, if there is any alleged infringement or if a patent is challenged. Two is providing clients with assistance in determining whether they have the freedom to act on a particular idea or proposal. Zafira: considering patents for a moment, are there any significant changes that require additional consideration? Simona: the greatest change in recent times is the implementation of the Unitary Patent Court, UPC. There are proceedings before the Unified Patent Courts, notably the Third Chamber, which has been set up in Milan and, due to the court's youth, outcomes are still incredibly significant to the industry. The rules are new and to some extent based on German procedural rules. However, we are managing this change very well and Italy remains strong in the area of urgent measures. This follows the Italian tradition of granting searches, which we are still heavily involved in. At present, the expertise of Italian judges in understanding and approving these measures proves to be a strength in this new environment. Of course, there are currently many cases that have been litigated at the national courts in Milan, which are also important. Zafira: in this new digital area, how do you advise brand owners who are looking for protection in relation to selling a new retail product? Simona: the advice given to a client in this area is very comprehensive. The new digital scenario has bigger challenges. This is because there is an international element involved in online e-commerce. On one hand, it is important to be very careful when selecting a brand. There must be considerable thought in selecting a brand because if there is any defect in your prior research relating to risk assessment, this may cause increased exposure and potential for issues to arise. On the other hand, obtaining the desired protection may be difficult depending on the type of product. In this area, technology can be used to help identify infringement. We have partners with whom we work that use technology, including artificial intelligence, AI. They create crawlers that are then launched on the web to identify situations that may pose a challenge or infringement. We use a combination of skills and tools that require interdisciplinary knowledge to advise clients of all potential risks. Zafira, there are well-documented complications for protecting innovations that have been created with the assistance of AI. What difficulties may arise when trying to obtain protection for such works? Simona, in relation to AI, we mostly work with companies in the fields of music and video games. From our experience, it is challenging to leverage AI in the process of content creation because the use of AI exposes the company to a number of risks. At present, there is no clear regulatory framework at international level, with significant conflict between regulations in different jurisdictions. A significant concern with AI use is hallucinations, which may cause liability disputes. As a firm, we are working with companies to explore how AI can be used within a proper structure. This will help the client avoid the risks of having employees using general AI based on consumer rather than business contract. Using general AI such as ChatGPT based on such contracts, you must agree to the terms of service. These may imply that using this service does not protect your know-how. In addition, you are not protected if you use the output provided outside of your own personal use. We also assist clients who create their own works, and in this respect we primarily deal with copyright misuse. This includes deep fakes or protecting prior works of art in cases where generative AI has created a very similar output. It is important to have an understanding of the technology when working side by side with those who are trying to develop AI. We must learn about how the models work, how the input phase and the output are created, and how the output appears at the end of the process. For example, in voice development, the voice skin is a key component. The voice skin is created by training AI to learn the elements needed to construct a voice without using a specific voice itself. This is different from a voice clone that uses a certain voice and has this voice speaking any language or any sort of expression. The voice is a complex asset because a voice changes based on the emotion that a person is feeling. This is an area where there is rapid development, and the creation of new features is incredible. Zafira, have there been any recent infringement claims in the area of art or design in Italy? Simona, in Italy, we have specific protections for art and cultural artifacts known as the Cultural Heritage Code. This covers a very broad range of assets, including for instance the Colosseum, and can include a specific type of material that is used to create a work of art. Recently, we had a case involving a stone known as marmo di Vitulano. It is a very specific type of marble only found in a couple of villages in the southern part of Italy. It is very famous because it has been used by a famous Italian designer, Vanvitelli, in the past to create the grand stair of the Reggia di Caserta. The Reggia di Caserta, in the south of Italy, was the place where the royal family, Savoia, stayed in the summer. Marmo di Vitulano has also been used in the Vatican. In the case involving this marble of Vitulano, there were other places in the surrounding area claiming that they were able to use the same kind of marble with a different brand name. This claim would have entirely diluted the value of the product and the brand of this specific type of marble. It is unique due to the place where it is found. We brought the case and obtained the recognition of the trademark via a settlement agreement. In this case, we argued for the protection also based on the grounds of cultural heritage. This ground is a mixture of something physical, the marble of a specific place, rich in history, connected with a famous artist in the 17th century, who developed this wonderful Reggia di Caserta, so it is very important for our heritage. Zafira, do you encounter many cases of unfair competition or instances where someone infringes on another person's rights by imitation? Simona, yes, this is a big issue, especially in the digital environment where we see a new kind of network creativity, which is based on remixes, mashups, recycling, and reusing the style of someone else. An infringement claim could be based on the infringement of an actual exclusive right or on the production of an imitation. Of course, we have to assess whether this kind of imitation is illegal. To a certain extent, reusing something that is just an idea that is available to everybody is not an infringement. On the contrary, reusing something that has been a distinctive element of the production of a competitor, especially if you do it on a regular basis, is a kind of parasitism. This creates confusion and infringes. So, we advise clients when there might be a risk. For example, in the realm of mass production, such as fashion, it is sometimes difficult to assess the freedom to operate when there are so many other entities producing similar kinds of products. We expect to be more involved in litigation surrounding the use of brand names or products that have an Italian-sounding name, given the recent situation with tariffs. I think that Italian companies are very worried about the production and distribution abroad of products with Italian-sounding brand names. Examples could include famous cheeses, like Parmesan, or famous wines that are not original or even made in Italy but have a similar-sounding name and are cheaper. In these situations, there are both issues of confusion and dilution, which may be relevant from the viewpoint of unfair competition. In addition, there may be Italian companies that are involved in producing a similar product locally. This product may not be exported, but still has the potential of creating confusion and/or dilution based on an Italian-sounding name. There are also situations that do not meet the threshold for brand infringement but still cause confusion. This can come to light when using the same concept. An example is a company that uses all of the initiatives of a competitor, without any investment in ideas or promotion, rather than infringing on a specific asset that belongs to someone else. Zafira. Today, there is vast amounts of information available. How do you determine what information is credible? Simona, that is a very important question, especially now that AI is commonly used. Today, AI is used by everyone, and they do not realize that the information is not double-checked. AI may be reasonably reliable when there is a large amount of information from a lot of different sources and the topic is well known. If we are talking about legal issues, especially those that are newly developing, using AI is extremely dangerous. We normally use traditional sources of reference, including the laws involved, books, and case law. We may use additional sources for information, but we always verify that the information is cross-referenced with different sources. AI doesn't necessarily do this. This is important because when you work in this field, you may encounter officials or parties who are decision makers. For example, you come into contact with a judge or with parties in a serious contract negotiation. In these scenarios, your reliability and, in turn, the reliability of the information you provide is key to your reputation. If you lose this, it is impossible to continue. In many cases, we go before the court, sometimes with very urgent, important requests. In such situation, it is important that judges know that the information you provide is reliable for them to consider the request very seriously. If, in a particular case, the judge sees that you have provided unreliable or incomplete information, and this is the basis for your request, which is later proven to be incorrect or illegitimate, then in the future the judge will treat your further requests with suspicion, thus being less inclined to consider or guarantee them. Zafira. Thank you, Simona, for sharing your valuable time and insights with us. Your perspectives on the evolving landscape of IP law, particularly in the context of Italy and emerging technologies, provide important insights and depth. We appreciate the opportunity to learn from your experience and look forward to following the continued work of LGV Avvocati. Page 42. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Patent thickets and overlap: how attorneys and analysts collaborate in the CRISPR Cas9 maze. Stand first: Joshua Beverley, Senior Patent Analyst at AIPPI World Limited, and Dr. Michael A. Roberts, Partner at Red Dye & Grows LLP, UK, examine the intricate legal challenges and patent complexities surrounding CRISPR Cas9 technology, highlighting the essential collaboration between patent attorneys and analysts. About the authors. Joshua Beverley is a Senior Patent Analyst at AIPPI World Limited and uses his expertise to unleash the power of patents, one analysis at a time. As a Senior Biotechnology Patent Analyst, Joshua dives deep into the world of intellectual property, decoding complex patent data with precision and finesse. With expertise in industry-leading databases and a passion for uncovering insights, he helps clients navigate the realms of freedom to operate, invalidity, patentability, and landscape searches. Dr. Michael A. Roberts is a partner at Red Dye and Grows LLP, specializing in life sciences, including biotechnology and plant protection. With a PhD in molecular genetics and years of hands-on experience in CRISPR-related filings, prosecution, and FTO advice, Michael brings sharp legal insight to complex patent landscapes. He works closely with innovators to protect breakthrough technologies and guide strategic IP decisions across global jurisdictions. The legal and commercial cost of innovation. In the patent world, innovation rarely arrives in neat packages. Nowhere is this more evident than in biotechnology, where the CRISPR-Cas9 gene editing revolution has spawned one of the most complex patent thickets in recent history. Defined as a dense web of overlapping intellectual property rights, patent thickets can create serious obstacles to commercialization, research, and litigation strategy. For biotech companies and patent attorneys, CRISPR-Cas9 isn't just a technical marvel, it's a strategic and legal challenge. The volume of filings, cross-jurisdictional inconsistencies, and continuation practices demand far more than a typical search. This is where collaboration with skilled patent analysts becomes critical. They don't just assist, they equip attorneys with the clarity and precision required to evaluate FTO, win interference proceedings, and identify strategic risk. As UK-based patent attorney Dr. Michael Roberts explains, analysts are no longer just doing the heavy lifting in the background. Their ability to visualize landscapes, spot legal inconsistencies, and trace priority chains has become indispensable. CRISPR-Cas9. The scientific spark that lit a legal wildfire. CRISPR, clustered regularly interspaced short palindromic repeats, and Cas9, CRISPR-associated protein 9, were initially identified in nature as part of a bacterial immune system that can identify and cut viral DNA. When repurposed by researchers, CRISPR-Cas9 became a molecular scalpel capable of editing genes with unprecedented precision and relative ease. Its versatility made it immediately valuable across medicine, agriculture, and synthetic biology. But this transformative power also triggered a patent rush. Institutions and companies scrambled to secure IP rights over methods, compositions, delivery systems, and applications. The result: a fragmented, hyperactive patent landscape that continues to mutate. For attorneys, this landscape isn't just crowded, it's legally unstable. Overlapping claims, inconsistent jurisdictional treatment, and deliberate ambiguity create significant hurdles. In the CRISPR dispute, the validity of key foundational patents and claims have come under sustained questioning, with this ambiguity leading to innovation paralysis. Roberts notes, it's not just about whether a claim is valid, but also how it may be interpreted differently in national or regional courts. Patent analysts are indispensable allies here, offering deep, structured insight into what's claimed, by whom, and where, so you can build a stronger legal or commercial case. The CRISPR dispute: why expertise in eukaryotic cell claims matters. The cornerstone legal conflict in CRISPR-Cas9 IP centers on who first developed the technology for use in eukaryotic cells and where it could be applied to plants, animals, and humans. Two academic giants are at the heart of the dispute. University of California, Berkeley, led by Jennifer Doudna and Emmanuel Charpentier, filed their first foundational patent application in 2012, with CRISPR activity demonstrated in a bacterial system. Their work earned the 2020 Nobel Prize, and the Broad Institute of Massachusetts Institute of Technology, MIT, and Harvard, led by Feng Zhong, filed their first patent application in 2013, with expedited review from the USPTO, demonstrating use in mammalian cells. The Berkeley team claimed broad applicability across all cell types, while Broad's claims were targeted to eukaryotic cells. These differences were nuanced but critical, and have driven years of litigation. In the US, the Patent Trial and Appeal Board, PTAB, initially upheld Broad's claims as patentably distinct. In Europe, however, the EPO granted key patents to Berkeley in 2017, including eukaryotic applications. In May 2025, the US Federal Circuit ordered the PTAB to revisit its ruling, arguing that key legal standards had been misapplied. CRISPR interference appeal numbers 2022 to 1594, 2022 to 1653. Roberts reflects, the Barclay Broad case was a wake-up call. Not just because of who won or lost, but because it showed how timing, multiple filings, expedited examination, and claim construction can completely change the trajectory of IP rights. Since then, we've seen more strategic drafting, filing narrowly initially to get an early filing, then expanding in follow-ons during the prior period in particular. Patent attorneys navigating this conflict require more than docket tracking. They need analysts who understand the nuance between claim scope, legal status, continuation filings, and international harmonization. Analysts can dissect how eukaryotic is defined and applied across filings, trace back to priority claims, and identify strategic continuations that shape the battlefield. Figure 1. Timeline of key CRISPR Cas9 patent events, from the first UC Barclay and Zhong filings in 2012, through Broad's 2014 eukaryotic patent and ensuing interference and appeal decisions, to the Federal Circuit's 2025 order to reconsider the PTAB ruling. The CRISPR patent thicket, a growing strategic hazard. From the first CRISPR Cas9 filing in 2012, the patent landscape has exploded. By 2024, over 8,000 patent families and 16,500 filings had been published globally. CRISPR isn't just crowded, it's contested and continuously expanding, with annual filings spiking post-2015 and have since remained steady at around 1/300 year, often with overlapping claims. Figure 2. Annual CRISPR Cas9 patent filings by earliest priority year, illustrating ramp-up from fewer than 100 applications in 2012 to a peak of roughly 1,390 filings in 2022 and stabilization around 1,300 to 1,400 filings per year through 2024. Please note that 2025 has been omitted due to incomplete data resulting from a delay of up to 18 months during the filing and application process. What emerges is a thicket which is near impossible to navigate without support. Attorneys rely on accurate landscape maps, claim comparisons, and enforceability reviews to conduct risk assessments and licensing strategies. Analysts provide this structure, but attorney interpretation remains key. In dense landscapes like CRISPR, an FTO opinion is never a simple yes or no, Roberts explains. It's often about risk tolerance. We can work closely with analysts to map out not just what exists, but what's lapsed, unexamined, or so narrow that it's commercially irrelevant. Why attorney-analyst collaboration matters. Patent analysts are embedded strategic partners. They enhance legal effectiveness across 5 key areas. Freedom to operate, FTO Roberts comments. Clients may be surprised by the existence of white space that is available once you start breaking claims down across jurisdictions and timelines. In the CRISPR case, distinguishing foundational filings, e.g. Broad's 2014 U.S. eukaryotic patent versus Barclay's global filings, from derivative or narrowing claims is critical. Analysts also track lapsed patents, withdrawn filings, or unexamined continuations, each of which can affect FTO. Litigation and disputes. In litigation, timing and claim language are critical. Analysts help attorneys unearth overlooked prior art, strategic amendments, and subtle prosecution patterns. In the CRISPR dispute, analysts have helped surface unnoticed prior art, identify misuse of examiner interviews or specific interpretations adopted during examination, and identify strategic amendments in continuations. These insights can assist with litigation arguments. Jurisdictional strategy. The divergence between EPO and USPTO decisions plays a crucial role. The same invention can have very different enforceability profiles across the Atlantic, says Roberts. You can't assume harmonization. Visualizing the landscape. High-level charts and heat maps transform raw filing data into strategic intelligence. Analysts chart yearly filing trends to reveal surges or plateaus in the CRISPR field, cluster assignees to highlight potential licensing partners or acquisition targets, and where white space remains open. These visual tools help attorneys advise on licensing, investment, or enforcement targets. Commercial advice. Attorneys use analyst-derived insights to steer clients toward viable R&D directions or licensing opportunities. It's collaborative, Roberts adds. They flag the risks, and we decide how to frame or respond strategically. When the landscape is dense, collaboration wins. CRISPR-Cas9's thicket is not an anomaly, it's a preview of biotech IP's future. With innovation outpacing regulation, it's not enough to simply understand the legal system, you need insight into how that system is evolving. Don't go it alone, Roberts advises. Patent thickets aren't solved with a single database or keyword search, they're solved through smart collaboration. You need both legal judgment and analytical precision. For patent attorneys and analysts alike, the CRISPR battlefield proves that clarity doesn't come from one expert alone, but from the combined strengths of both.
Page 45. Advertisement. The Caribbean IP Annual 2026. Promoting IP excellence in the Caribbean. Join the 2026 edition of the Caribbean IP Annual. The Caribbean IP Annual returns after a standout debut, launched at ANTA 2025, and remains in circulation at leading IP events worldwide. Building on the momentum of our first edition, we continue to map the Caribbean region's evolving IP landscape with clear, jurisdiction-by-jurisdiction insights and practical commentary from leading voices. IP law firms, practitioners, and businesses, secure your feature to showcase your expertise to a targeted international readership actively seeking referrals and cross-border collaboration across the Caribbean. Contact us at www.caribbeanipannual.com or email cipannual@northonsprmarketing.com or call +44 02 03 813 0457. Page 46. Advertisement. Vaknina and Partners, Russia. Eurasian and Russian patent and trademark attorneys. Patents, utility models, designs, trademarks. Dr. Tatiana Vaknina, Dr. Alexey Vaknina, and Dr. Elena Utkina. EAPO, Armenia, Belarus, Kazakhstan, Azerbaijan, Georgia, Moldova, Armenia, Russia, Kyrgyzstan, Tajikistan, Turkmenistan, Uzbekistan. Contact. Russia, ip@vaknina.com. Armenia, am@vaknina.com. Kyrgyzstan, kg@vaknina.com. www.vaknina.com. ip@vaknina.ru. Tel +74959467075.
Page 47. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. The digital disconnect: 78.57% of IP professionals seek clarity in tech platforms. Stand first. In light of recent, real-world insights revealed by the Global IP Tech Survey 2025, Carlos Northern, founder and CEO of Northern's Media PR and Marketing Limited, highlights the pressing need for clarity and guidance in the rapidly evolving landscape of IP technology. As the intellectual property (IP) sector continues to embrace digital transformation, one question remains: how well are current technologies meeting the practical needs of professionals on the ground? To help answer this, Northern's Media PR and Marketing Limited recently conducted one of the most comprehensive global surveys of its kind. Distributed to over 6,000 IP professionals across the globe, including in-house counsel, private practice lawyers, innovation leaders, and legal technologists, the Global IP Tech Survey 2025 offers a real-time snapshot of how IP tech tools are performing today and what users truly need going forward. Rather than focusing on theory or speculation, the survey sought to capture real-world experiences. Respondents were invited to share their views on key areas such as platform usability, onboarding support, system integration, and market transparency. The findings have not only highlighted where progress is being made, but also where significant improvements are still needed. One of the most telling results relates to market awareness. Only 21.43% of professionals felt well informed about the IP platforms available to them. More than half, 53.57%, said they were only somewhat informed, while 25% admitted they did not feel informed at all. This lack of clarity was further reflected in perceptions of transparency. Just 32.14% of participants believed the current market is transparent enough to make informed decisions, while the remainder were either unsure or did not believe it is. Notably, 78.57% of professionals expressed the need for greater clarity and guidance when evaluating IP platforms, signaling a widespread desire for objective, accessible, and comparable information. This figure alone underscores the growing urgency for structured support in navigating a crowded and often confusing digital landscape. Confidence and usability concerns. Confidence in choosing the right technology is shaky. Only 21.43% of respondents said they felt confident when selecting a platform. The majority, 64.29%, described themselves as only somewhat confident, and 14.29% said they were not confident at all. Many professionals appear to be making decisions based on peer suggestions or vendor marketing, rather than structured comparisons or impartial guidance. These issues are compounded during the onboarding phase. Just 32.14% of participants said they consistently received adequate support when adopting a new platform. Half reported that support was provided only occasionally, while 17.86% said they rarely received any. Without consistent onboarding, even the most advantageous tools can fail to deliver value. When it comes to ease of use, only 28.57% found their current IP platforms user-friendly. The majority, 60.71%, said platforms were only sometimes intuitive, and a further 10.71% found them difficult to use. From clunky interfaces to poor workflow integration, the user experience remains inconsistent across the board. A call for independent guidance. Amid these challenges, the sector's appetite for a structured, transparent resource is stronger than ever. When asked whether the IP industry would benefit from an annual guide comparing platforms based on functionality, integration, and user feedback, 89.29% of respondents said yes. The remaining 10.71% said maybe, with not a single participant rejecting the idea. There was clear interest in content such as functionality comparison, onboarding quality assessments, cost breakdowns, regional adaptability, and user satisfaction ratings. Many comments submitted alongside the survey echoed this desire. I would like to see what's really working, not just promotional materials. Feedback from actual users in my region would be incredibly valuable. Cost should be affordable to small and medium enterprises. Most platforms are built for large corporations. The biggest issue we face is integration. Most platforms don't fit our legal ecosystem without heavy customization. More transparency is needed when it comes to pricing and performance comparisons. We are always told every product is the best. These remarks paint a clear picture. Users are asking for better tools, but more importantly, better information about those tools. Introducing the IP Tech and Innovation Services Annual 2026. In response to this overwhelming feedback, Northlands Media is proud to announce the launch of the IP Tech and Innovation Services Annual 2026. This dedicated reference guide is being developed specifically to meet the needs raised in the survey. It will serve as an independent, comparison-led resource to help IP professionals make more confident, informed decisions about the technology they choose. Unlike standard legal publications, this new annual will focus solely on the platforms, tools, and systems transforming IP workflows. It will feature case studies, user testimonials, expert commentary, and platform evaluations, all aimed at creating clarity and building trust in the technology space. An invitation to the IP tech community. As the industry moves forward, we invite IP technology providers to be part of the solution. The survey results have shown that users are no longer satisfied with generic marketing claims. They want transparency, performance data, and user-led insights. Now is the time to help bridge that gap. By participating in the IP Tech and Innovation Services Annual 2026, providers have the opportunity to showcase their offerings in a format that truly speaks to the needs of their audience. Whether through sharing implementation stories, highlighting customer success, or contributing to educational content, your voice can help shape a more transparent and user-focused IP tech environment. Invitation to IP technology service providers. If you would like to showcase your platform and share the value it brings to the IP community, please contact at technovation@northernsprmarketing.com, website www.iptechnovation.com. Call for insights from IP technology users. If you would like to share your experiences and contribute to shaping the future of IP technology, please contact at technovation@northernsprmarketing.com, website www.iptechnovation.com. Page 49. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. From Fragmentation to Integration, UNH Franklin Pierce's Hybrid JD and the Future of Global IP Education. Stanford. Professor Seth C. Orenberg of UNH Franklin Pierce School of Law, USA, discusses the necessity for a cohesive approach in IP education to meet the challenges of a globalized economy. IP disputes now ignore legal labels like national borders and doctrinal categories as easily as online students miss office hours. In August 2023, Huawei in Shenzhen and Ericsson in Stockholm renewed a multi-year cross-license covering thousands of 5G standard patents, letting each company sell hardware worldwide without fear of injunctions. In March 2024, the Toronto District School Board sued Meta, TikTok, and other social media giants in Ontario's Superior Court, alleging platform design harms student well-being. The court refused to strike the claim in March 2025, and the case now heads toward discovery. When the AI-generated track Heart on My Sleeve, featuring synthetic Drake and the Weeknd vocals, went viral on TikTok in April 2023, Universal Music Group forced takedowns from Spotify, Apple Music, and YouTube within 48 hours while the song kept circulating on other platforms. One fact pattern, many legal issues. That is the modern IP lawyer's landscape. Legal education rarely mirrors this reality. A 2025 survey of 30 Chinese national IP demonstration universities found courses concentrated almost entirely on patents, leaving trademark, copyright, and trade secret law to scattered electives or library workshops. The study calls IP instruction lacking in systematization and coherence. North America and Europe display the same pattern. Doctrinal fragmentation breeds practitioners who master a piece of the puzzle but struggle to assemble the whole. UNH Franklin Pierce School of Law is pioneering a different model. In 2019, it launched the Hybrid JD in Intellectual Property, Technology and Information Law, the only ABA-accredited JD built expressly around IP and delivered primarily online. Every student begins with Fundamentals of IP, a gateway course mapping relationships among patents, trademarks, copyrights, and trade secrets before electives begin. Core doctrine then returns repeatedly to integration, how EU design rights reinforce US trade dress claims or how a pharmaceutical patent portfolio dovetails with confidential manufacturing data, so students learn to think across geographic and doctrinal boundaries from day one. Distance delivery is no afterthought. Asynchronous online classes are punctuated by strategic in-person immersion sessions in Concord, New Hampshire, in Silicon Valley, and even in Hawaii, where practice-oriented learning forms the program's spine. Even remote students can engage with the Intellectual Property and Transaction Clinic, which handles trademark and copyright registrations, agreements like licensing and non-disclosure, and IP counseling for entrepreneurs who could not otherwise afford counsel. Building on this innovative JD model, UNH Franklin Pierce also offers established programs like the LLM in Intellectual Property, Master of Intellectual Property, MIP, and Graduate Certificate in Intellectual Property, all with 100% online options, alongside residential formats. For more than a decade, Franklin Pierce has been pioneering accessible IP education that allows working professionals worldwide to advance their careers without relocating or leaving jobs. Additionally, the long-standing Intellectual Property Summer Institute, IPSI, provides an intensive, short-term immersion for IP professionals to learn about cutting-edge topics in IP, access world-class faculty and industry leaders, and network with IP professionals. The virtues of this systems approach are evident from an industry perspective. A Boston designer using Midjourney to create textile patterns might need design patents, trade dress protection, and copyright licenses. UNH Franklin Pierce students tackle these issues throughout their integrated program. Other schools might produce students who earn IP certificates without ever learning about the Uniform Trade Secrets Act. The takeaway is clear: clients seldom present siloed problems, so law schools must not cling to teaching in siloed doctrines. Global orientation should be baked into IP. At Franklin Pierce, visiting faculty from WIPO and the European Patent Office lead comparative modules, students brief clients in Lagos and Munich from the same virtual classroom, and the International Technology Transfer Institute exposes learners to cross-border licensing. Results are encouraging. UNH Franklin Pierce graduates land positions at IP firms and tech companies from Bengaluru to Boston. Employers praise graduates' plug-and-play versatility, lawyers who can map an entire IP bundle without calling for specialists. UNH Franklin Pierce alumni, including those from IP-focused programs like the hybrid JD and LLM in intellectual property, practice in over 80 countries, directing policy in governments and holding leadership roles at Law 100 firms. They serve as professors, policymakers, corporate lawyers, and managing partners, with notable placements at Microsoft, Bayer, Pepsi, Frito-Lay, Fox, Samsung, LG, and Equinox Fitness. Alumni have also led governmental IP offices in Taiwan, Argentina, Japan, and Nigeria. Hybrid JD graduates, such as those in the inaugural 2022 class, have transitioned into roles ranging from quantum computing startups to IP boutique firms, leveraging the program's flexibility for mid-career professionals from tech and engineering backgrounds to enter high-impact global IP practice. WIPO's World IP Indicators 2024 report shows innovation hubs multiplying. Global patent filings reached 3.55 million, while trademark applications covered 15.23 million classes. If the 21st century economy is built on intangibles, 21st century IP education must transcend boundaries as well. UNH Franklin Pierce's hybrid JD offers one workable route: marry online access to immersion clinics, insist on a systemic doctrinal core, and invite the world into the classroom. The question is no longer whether integration is feasible, it is how quickly the rest of us will follow. Seth C. Orenberg is Professor of Law at UNH Franklin Pierce School of Law and author of A Systems Approach, Teaching Intellectual Property in Our Interconnected World, forthcoming in AIPPI's El Rol de la Universidad en la Propiedad Intelectual, The Role of the University in Intellectual Property, in collaboration with Universidad Andina Simón Bolívar, Ecuador, to be launched at the 23 AIPPI Congress in Buenos Aires, December 2025. Page 51. Article. Disclaimer. Images and references related to this article can only be seen in the print and digital versions of the magazine. Protecting a Trade Secret from the West to the East. Stand First, written by Zafira Hudani, reporter at Northlands Media PR and Marketing Limited, United Kingdom. The U.S. The U.S. Patent and Trademark Office defines a trade secret as information that has actual or potential independent economic value because it is not generally known. The value of this information is created by restricting access to it. This means that others cannot legitimately obtain the material. In addition, it must be shown that reasonable efforts have been made to keep the data secret. Both criminal and civil penalties may be imposed if the court determines that a theft of trade secrets has occurred. Criminal penalties may arise under the Economic Espionage Act of 1996, and civil penalties may be imposed under the Defend Trade Secrets Act of 2016. The civil offense is defined as the misappropriation of a trade secret. The judicial system allows for the enforcement of protection of trade secrets by a. Ordering that the misappropriation stop, b. That the trade secret be protected from public exposure, and c. In extreme circumstances order the seizure of the misappropriated trade secret. Many claimants wish to have their day in court with respect to trade secrets. A case involving Samsung is an example of where a claimant was successful. Here, employees in the company's semiconductor division were provided with the option to use ChatGPT to assist in resolving issues with the source code. In this process, proprietary information, including trade secrets, was inputted into ChatGPT and stored in the database. The trade secrets became information available to the public, exposing the information that created value for the company. The employees who were found liable received prison sentences. The recent case of XP Power v. Comet Technologies illustrated how courts use damages to deter the theft of trade secrets. Both companies produced products including semiconductor chips, radios, and power supply materials. The alleged misappropriation occurred when XP Power purposely hired Comet's leading engineers, who downloaded the files and took them to XP Power. At the completion of the trial, Comet Technologies was awarded $40 million in damages. Due to the deliberate employment of Comet Technologies engineers, the company was awarded $17 million in attorney's fees. India. India is a signatory to the TRIPS agreement. According to India's Trade Secrets Bill 2024, a trade secret is defined as information that is not known, secret, to persons that deal with such kind of information, secrecy, deriving commercial value on account of being a secret, subject to reasonable steps by the owner to keep the information secret by the holder or owner and disclosure of which is likely to cause damage. The information above shows that the definition of a trade secret is similar in both the East and the West. However, it is important to note that there is no specific offense of trade secret misappropriation in India. The landmark case of Beyond Dreams Entertainment Private Limited v. Z Entertainment Enterprises Limited and Anna, 2015 SCC Online Bomb 4223, defined the elements of a trade secret based on established case law. The three aspects that constitute a trade secret are that the information must be confidential in nature, the person receiving the information must have a current obligation to keep the information in question confidential, and that the data must not be accessible or have the potential of being appropriated by an individual who lacks authorization to obtain it. In addition, there is a possible cause of action that may arise if there exists a potential apprehension that data may be disclosed. The case of HCL Technologies v. Sanjay Ranganathan, the 27th of July 2023, in CS. Com. 502/2023, is an example of trade secret theft. A former employee of the company revealed confidential material by using an email account. This data was personal to the company. As such, sharing it was prohibited without the company's knowledge and permission. The court stated that if issues relating to confidentiality are subsequently raised, then these concerns could have a negative impact on the company's ability to function. An example of the range of applicability of the duty of confidentiality has been shown in the case of Z Telefilms v. Sundial Communications, 2003, 5 Bomb County Route 404. The court held that the obligation to uphold the confidentiality of information extends beyond the original recipient of the information to any person who knew that the information was protected. As shown from the examples above, the value of a trade secret is derived from protecting confidential information. A trade secret can include an idea or a process that is unique. It is vital to keep in mind that the person looking for protection should be aware of the subject matter that can be afforded protection. This is partly because the future of trade secrets is unpredictable. The safeguard that a trade secret provides will depend on technological advancements. The current legal systems will determine the magnitude of the impact these advancements have. For now, it is key to prevent the disclosure of information that can be protected as a trade secret.
Page 53. Conference Corner. 2025 Voices of the Associations. Luis Enriquez, President of ASIPI. Daniela Bopp and Elena Backhouse, Senior Conference Manager and Team Lead Sales at IP Service World. Cosmonauts, Organizer of Future IP Europe and Future IP Conferences, UK. This segment is dedicated to our esteemed IP event organizations and associations with whom we have established media partnerships across the globe. We are privileged to provide them with a platform to keep you, our valued audience, well informed about upcoming events and the latest trends in IP conferences throughout the year. By staying connected with us, you can ensure that you never miss out on any of these significant international events and enriching seminars. The Global IP Matrix. Official Conference Media Partners. For 2025 Conference Media Partnerships. Contact info@gipmatrix.com. Page 54. Advertisement. ASIPI, Buenos Aires. 23rd Congress. Hilton Hotel, Buenos Aires. From November 30th to December 3rd, 2025. Early bird deadline is September 25, 2025. www.asipi.org.
Page 55. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. ASIPI, in motion, vision, action, and regional impact. Stand first. Reflecting on his presidency, Luis Enriquez highlights the transformative journey of ASIPI as a vital community committed to strengthening the IP ecosystem throughout the Americas ahead of the 2025 event. A community working for a better future. As I enter the final year of my term as president of the Inter-American Association of Intellectual Property, ASIPI, I do so with deep gratitude and a clear sense of purpose. Over the past 2 years, ASIPI has reaffirmed its role as a key platform for dialogue, collaboration, and leadership in the field of IP throughout the Americas. More than just an association, ASIPI is a living community that connects professionals, academics, public institutions, and international organizations, all working together to strengthen the IP ecosystem in our region. This spirit of collective effort and strategic vision has guided our actions and will continue to shape our agenda moving forward. Strengthening our institutional voice. In recent years, we have focused on consolidating ASIPI's institutional presence and expanding the reach of our initiatives. Our relationships with global organizations and regional IP offices have grown stronger, generating new opportunities for cooperation and policy dialogue. These alliances allow us to bring the Latin American perspective to international forums while executing initiatives that benefit our member countries. We have also made significant progress in the academic field, especially through ASIPI Academia. Our scholarship programs, essay competitions, and university partnerships have promoted high-level training and opened new paths for young professionals. In parallel, we have deepened our commitment to social responsibility and professional ethics. The launch of our institutional campaign, We Respect, marked an important milestone for ASIPI, reflecting our core values and identity as an association. Diversity, inclusion, and integrity are not merely abstract principles within ASIPI, they are the foundation of how we work, connect, and grow as a community. A time to come together. Looking ahead, we are preparing for one of the most emblematic moments of our organization, ASIPI's next in-person Congress, to be held from November 30th to December 3rd, 2025, in Buenos Aires, Argentina. This event will bring together the international IP community for a series of high-level academic discussions on the most relevant and pressing issues of today and tomorrow. During the ASIPI Buenos Aires Congress, we will discuss topics such as trademarks, patents, artificial intelligence, geographical indications, fashion law, and anti-piracy strategies, among others. In addition, there will be technical workshops focused on jurisprudence updates, arbitration mechanisms, and innovations in the area of plant varieties. Beyond the academic content, the Congress will be a space for meaningful connection, a few days to come together and exchange ideas, build new alliances, and renew our shared commitment to IP as a tool for regional development. It will also mark the conclusion of my presidency, and I can think of no better setting to reflect on what we've built together and to celebrate the continuity of our collective vision as an association. IP with human purpose. What defines ASIPI is not only the quality of its content, but the spirit with which it is delivered. Every seminar, every publication, and every project is driven by the belief that IP is not an end in itself, but a powerful lever for economic, cultural, and social progress. This belief has shaped our work with entrepreneurs, local producers, policymakers, and the broader legal community. It drives our research into emerging issues such as cannabis regulation, brand restrictions, traditional knowledge, and sustainable innovation. And it also guides our ongoing efforts to open the IP conversation to new audiences, sectors, and territories. Always in motion. ASIPI moves toward the final stretch of 2025 with the energy of an organization that continues to grow, evolve, and lead. We do so with the strength of over 1,100 committed members, the support of our global partners, and the confidence of a region that increasingly recognizes the value of IP. It has been an honor to lead this association, and I look forward with enthusiasm to the months ahead, a time of intense activity, dialogue, and the transformative energy that has always defined us. Because ASIPI, now more than ever, is always in motion.
Page 56. Advertisement. H.K. Acharya and Company, India. Advocates, patent and trademarks attorneys. Protecting innovations, securing future. Our services: patent, design, IP litigation, trademarks, licensing, IP valuation, copyrights and many more. Contact details: HK Avenue 19, Svastik Society, Navrangpura, Ahmedabad 380009 India. Telephone, +917926425258/5259, fax, +917926425256 and 2/5 info@hkindia.com. Website, hkindia.com.
Page 57. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Where global IP leaders connect and shape the future, Daniela Bopp and Elena Backhaus share their perspectives on IP Service World 2025. Stand first. Zafira Hudani, reporter at Northlands Media PR and Marketing Limited, speaks with the key organizers of Europe's largest IP event to give you a peek behind the curtain. IP Service World is more than just an event, it's the vibrant hub of the European IP community. On November 24 to 25, 2025, more than 1,000 participants, including key decision-makers, innovative solution partners, and industry pioneers, will come together in Munich to explore the future of IP. For 15 years, the event has inspired, connected, and pushed boundaries. This anniversary edition promises even more. Ahead of the event, we sat down with IP Service World's Daniela Bopp, Senior Conference Manager, and Elena Backhaus, Team Lead Sales, to gain key insight from behind the scenes. Zafira, IP Service World keeps evolving. What are some of the major themes and innovations in this year's program? Daniela, a central focus this year is the impact of generative AI on IP workflows. From research and strategy to automation and collaboration, AI, especially large language models, is changing how IP teams and law firms work together. We're delighted to welcome Dr. Lisa Sprenger and Dr. Silvio Haider from Weissman Climate Solutions, sharing how generative AI powers patent research, and Minoru Majijima from Resonac, exploring AI-driven strategic IP decisions. Other key topics include digitalization, cost efficiency, automation, sustainability, and how to future-proof global IP teams. Our program offers a blend of practical sessions and future-focused insights to equip attendees for the changing world of IP. Zafira, are there any keynote speakers that attendees should particularly look out for? Daniela, this year's keynote from Charlotte Ljungdahl, Senior Vice President of Intellectual Property, at ABB, demonstrates how resilient, globally distributed IP teams thrive. I'm always inspired by how our industry evolves through openness and collaboration. Professor Dr. Michael Burskens from the University of Passau will also provide practical insights on how AI is shifting dynamics between in-house teams and external counsel. These perspectives are unique to IP Service World, offering real-world inspiration for both new and experienced professionals. Zafira, how does the event help foster collaboration and interaction among participants? Daniela, collaboration is at our core. Our interactive roundtables and discussion formats are designed for genuine dialogue and fresh thinking. The event app lets participants connect in advance and schedule targeted meetings, turning introductions into lasting partnerships. Many meaningful business relationships have started with a focused roundtable or a simple meeting arranged on-site. Our goal is to make every conversation a chance for collaboration. Zafira, what's particularly valuable for exhibitors and partners at IP Service World 2025? Elena, few events offer such direct, natural opportunities. Over 1,000 attendees, including decision-makers and industry pioneers, are open to new solutions, making this the perfect place to form genuine partnerships. Our welcoming atmosphere means networking happens everywhere, Whether you're enjoying specialty coffee from our barista hosted by Up2IP, getting your shoes shined, or relaxing in the meeting and relaxing zone hosted by LexisNexis. One exhibitor told me, "I made more genuine contacts in one day here than in 6 months elsewhere." That's the power of IP Service World: honest conversations, quick connections, and relationships that last. Zafira, how do the evening events contribute to the overall conference experience? Elena, our evening events are unforgettable. On Sunday, after exhibitors set up their booths, the community gathers in the exhibition hall for finger food, drinks, and a joyful reunion. It's a moment of real excitement as old friends and new faces come together. Monday night is the highlight, with our celebration at Munich's traditional Augustiner restaurant. Whether catching up in a quiet room, posing for the photo booth, or dancing late into the night as the DJ plays, these moments create lasting memories and spark new collaborations. Many partnerships have started with a conversation over a drink or a shared laugh on the dance floor. Zafira, what feedback are you receiving from participants and exhibitors? Elena, the feedback is overwhelmingly positive. Attendees praise the content quality, international mix, and the chance to meet so many solution providers. Exhibitors have said it's one of the best lead generation events in their calendar. Many have joined us from the very first edition, proof of the strong community we've built. Marco Richter, Commercial Head of EMEA and South Asia, Global Consulting and Solutions at LexisNexis, said, "We value our partnership with IP Service World as it connects the global IP community and offers a unique platform to exchange insights, explore trends, and showcase how our solutions unlock the strategic value of IP." Michael Gollwitzer, Head of Corporate Intellectual Property Support at Siemens AG, adds the corporate view. IP Service World is the unique event where it is possible to get a quick overview of the latest developments and trends in the IP service sector and to talk to all major IP service providers. IP Service World is more than just an event, it's home for everyone passionate about innovation in IP. Daniel Holzner, CEO, ABP Patent Network, sums it up perfectly. "There's no doubt that IP Service World is the leading trade fair for the Dutch region, and beyond. Anyone who lives and breathes IP cannot afford to miss the chance to present themselves and connect here. Whether you're seeking the latest insights or ready to accelerate your business, IP Service World is the one event you can't afford to miss in 2025. Secure your place as an exhibitor, speaker, or participant and see how real opportunities grow from meaningful encounters. We look forward to shaping the future of IP together in Munich."
Page 60. Advertisement. Advert 1. Future IP Europe. Dublin, Ireland, 16th and 17th of September 2025, at Enterprise Ireland Offices and Convention Centre Dublin. 250 plus attendees, 40 plus speakers, 10 plus exhibitors. Agenda overview. Day 1, Irish Innovation, IP Capital Strategy, and SME Licensing. Day 2, AI and the Law, Data-Driven IP, Trade Secrets, UPC and Beyond. Interested in speaking at Future IP Europe? Email us at register@cosmonauts.biz or explore@cosmonauts.biz to participate as a sponsor. Advert 2. Future IP UK London, United Kingdom, 15th of October 2025, America Square Conference Centre. 300 plus attendees, 10 plus speakers, 10 plus exhibitors. Agenda highlights. Generative AI and IP ownership, global dispute mechanisms, brand protection at scale, real-world IP strategy stories. Interested in speaking at Future IP UK? Email us at register@cosmonauts.biz or explore@cosmonauts.biz to participate as a sponsor.
Page 61. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Navigating the Future of IP: Why Europe and the UK Are at the Centre of Global Innovation. Stand first. The upcoming events, Future IP Europe and Future IP UK, introduced by Cosmonauts, London, UK, are set to be pivotal gatherings, addressing the evolving IP landscape in Europe and the UK, focusing on the impact of emerging technologies and regulatory changes on global innovation. The IP landscape in Europe and the UK is undergoing transformation, and with it, so too is the way innovators, legal practitioners, governments, and businesses are navigating strategy, regulation, and value creation. Globalization, the digital economy, and the rapid adoption of emerging technologies have redefined the very nature of IP. Today, patents are being filed for inventions that didn't exist 5 years ago, copyrights must contend with AI-generated works, and trademarks face challenges from a global marketplace where brand recognition can spread or be imitated overnight. As a result, IP is no longer a niche legal concern, it has become a boardroom priority, influencing investment decisions, market entry strategies, and competitive positioning. In this shifting environment, access to timely insights, robust professional networks, and practical strategies has never been more critical. It is against this backdrop that Cosmonauts brings together two landmark conferences, Future IP Europe, formerly Dublin IP and RAND Summit, and Future IP UK, formerly London IP Week, each designed to tackle urgent questions from a regional and global perspective. Taking place in Dublin and London, these events serve as strategic platforms where the brightest minds in law, technology, policy, and business meet to map the future of IP. The European IP ecosystem has matured into a more cohesive and agile system buoyed by legislative reforms, digitalization, and pan-European collaboration. The establishment of the Unified Patent Court, UPC, and the full rollout of the Unitary Patent System in 2023 marked a historic moment, creating a more streamlined patent application and enforcement framework across participating EU countries. This development alone is expected to cut patent litigation costs by up to 70% for companies operating across borders, according to the European Commission. Meanwhile, the UK's departure from the EU catalyzed its own strategic IP realignment. Today, the UK stands as a flexible IP jurisdiction that, while no longer part of the EU framework, is leveraging its regulatory independence to foster innovation. Recent updates from the UKIPO on AI-generated inventions and copyright signal a jurisdiction that is both responsive and forward-looking. Together, Europe and the UK now represent two complementary models of IP governance, one leaning into integration, the other into autonomy, both vital in a multipolar innovation economy. Across both regions, several forces are reshaping the conversation. Generative AI has become deeply embedded in business and creative workflows, raising urgent questions around authorship, ownership, and infringement. In the EU, the debate continues over whether AI-generated content warrants copyright protection, while the UK is exploring adjustments to existing frameworks. For instance, in 2023, CoinDesk reported that the European Union Intellectual Property Office successfully trialed a blockchain-powered anti-counterfeiting system, creating immutable digital twins of products to help verify authenticity and detect counterfeits across the supply chain. As globalization accelerates, cross-border brand strategies have become more complex, requiring businesses to secure both EU-wide and national protections. At the same time, sustainability is emerging as a factor in IP portfolio design, with green innovation pushing practitioners to structure rights in ways that support ESG reporting and sustainable investment. Yet even in this dynamic environment, systemic challenges remain. Many startups and SMEs still struggle to realize the full commercial value of their IP. The European Patent Office reports that only 9% of SMEs in Europe file for patents, often due to cost and procedural complexity. Knowledge transfer between universities, public institutions, and private enterprises is uneven, limiting the flow of innovation into the market. And while technology moves at breakneck speed, the legal frameworks governing AI, quantum computing, and immersive technologies lag behind, creating uncertainty for rights holders and enforcement agencies alike. Future IP Europe and Future IP UK are built to address these realities head-on. Future IP Europe, taking place on 16 to 17 September 2025 in Dublin and hosted in partnership with Enterprise Ireland, will spend its first day exploring Ireland's IP investment climate, SME support structures, and capital strategies. The second day expands to a Europe-wide focus, examining issues such as AI and copyright, the unitary patent, and the future of cross-border brand enforcement. More than 40 expert speakers and 250 curated attendees will contribute to an agenda designed to produce actionable takeaways for investors, legal practitioners, and policymakers. Future IP UK, scheduled for the 15th of October 2025 in London, offers a sharp, one-day format aimed at decision makers. The program will feature TED-style talks, fireside chats, and in-depth strategy sessions on topics such as generative AI, global dispute resolution, and commercializing IP assets. With 300 participants and 35-plus carefully selected speakers, it will provide concentrated access to the latest UK and international IP policy developments. Cosmonauts recognize that thought leadership in IP cannot be confined to the stage, it must be built collaboratively. That is why we are inviting legal experts, inventors, academics, and technology leaders to bring their perspectives to Future IP Europe. We're opening the floor to those ready to share bold insights, challenge conventional thinking, and play a direct role in shaping the future of IP. For those committed to advancing their IP strategy, these events represent an unmissable opportunity. Registration is now open for both conferences, and attendees are encouraged to use the code Northons, complimentary for IP owners in-house corporate, when booking for Future IP UK and Future IP Europe. Future IP Europe can be explored at www.futureipeurope.com and Future IP UK at www.futureipuk.com. In a global economy where innovation is currency and IP is the mechanism that safeguards and monetizes it, the ability to anticipate change and act decisively will define the leaders of tomorrow. This September and October, Dublin and London will be the places where that leadership takes shape.
Page 63. Inside back cover advertisement. Northons Media PR and Marketing Ltd presents the IP360 Hub. The IP360 Hub, Directory 2026, the global industry guide connecting the global IP community. IP lawyer, counsel, service providers, advisors, industry partners. Limited time offer, annual packages starting at only £349. What you get: dual presence, print plus digital for maximum reach, verified listings among trusted IP professionals, premium community access for networking and collaboration. Your place in the IP360 Hub is just a few clicks away. It's fully automated. Choose your package, pay by card or invoice, follow our emailed instructions, and upload your content at your convenience before the February 2026 copy deadline. Visit www.ip360hub.com, email us at info@ip360hub.com or call us at +44 2038130457. Expand your network and visibility.
Outside back cover advertisement. Final page. Pat World, Global IP Research Services and Training. Pat World resurrects services. Trusted, reliable, accurate. The Pat World team combines scientific expertise with commercial insights to deliver comprehensive IP research solutions. Our services partner with a team trusted by tech companies, universities, and IP professionals worldwide. Freedom to operate searches, patentability assessments, validity analysis, competitor and technology tracking. Coming soon, CPD Certified Introduction to Patent Searching online course, relaunched in October 2025. Get in touch. Phone +44 016338166601. Email mail@patworld.com. www.patworld.com. Innovation House 6 Cedar Court, Celtic Springs, Newport NP10 8FY.
You have been listening to issue 23 of the Global IP Matrix magazine. If you would like to be part of the industry's #1 IP publication to share your knowledge with the global IP community, then please reach out to us at telephone +44 0203 813 0457 or email us at info@gipmatrix.com. Visit our website www.gipmatrix.com. Thank you.